Lordship, may I permit to mention it?
Yes.
Appellate said contempt matter.
Contempt.
Grateful, my lord. My lord, 4 matters.
Item number 1.
Lordship, this is for withdrawal. The no due certificate have been received.
Petitioner seeks to withdraw the present petition in view of the settlement arrived between the parties.
No due certificate.
Petition dismissed as withdrawn. All interim orders stand for it.
Ma'am, for the petitioner, Lordship. For correction, we have indicated the corrections here, Lordship.
Nishad, necessary correction will be carried. Do indicate क्या है?
Lordship, just to indicate, the account number is mistakenly written as there's a less zero, basically.
1 less 0.
Yes, and instead of Public Works Department, it will be Public Health Department. That's the only correction. Grateful, Lordship.
You are appearing in this.
Your Lordship, I'm for the award holder. There is a settlement between the parties. Kindly withdraw the matter. Just recall the warrant of arrest and vacate the interim orders. Any.
Learned counsel for the petition states that the matter has been amicably settled between the parties. She wishes to withdraw the present petition. The same is dismissed as withdrawn. All interim orders stands vacated. Warrant of arrest stands discharged.
Your Lordship, there has been also settlement between the parties. Kindly withdraw the matter and vacate the interim order.
Warrant of arrest stands cancelled. Item 4. Same order. Is there a warrant of arrest in item 4 also? No. All interim order stands.
Item number 5.
I'm possibly
5, I'm appealing for the petitioner. This has come for extension of interim order, Lordship. This interim order was granted in 2023. This is a section 37 appeal from a section 16 order. Appeal from a section 17 order. Yes, Lordship will see the last second page of that order. The respondent is directed not to sell the vehicle until further orders are passed by this court.
30th of April, what had happened? 2023.
Nothing happened, Lordship. This
is a section 17 appeal, right?
17 appeal. This is a section 37 appeal from a section 17 order, Lordship.
So what had happened? What is the stage of the arbitration?
Arbitration, Lordship,
What is the stage of the arbitration? Final award has been passed?
No. Till then, they have not passed any award.
Lordship, I'll apprise this duration. Lordship, first I'll explain the conduct of the respondent. Lordship, no mentioning notice was served upon us. They have mentioned the matter. No notice was served upon us. Lordship, just check the conduct of the petitioner, appellants. Lordship, secondly, Your Lordship, the entire thing, the entire jurisdiction is entirely in Bihar. The loan agreement was in Bihar. The arbitration was in Bihar. This court does not have any jurisdiction to entertain the application. And moreover, Your
Lordship, we are at
I
the
have instruction.
extension of interim order stage. If
Lordship,
it is
in
argued, we can
Order, please look at this. How can I just stay the interim order? Extension of interim order is not mechanical.
No, I'll produce those judgments, Lordship. This
Lordship, they are-
judgment, this interim order was passed on the
when-
basis of a coordinate judgment, Lordship.
There has been no, wait a minute, Mr. Saha, there has been no stay since 2023.
No, I appreciate, Lordship. We did not mention the matter for extension of interim order, but this order was passed on the basis of a series of judgments passed by a coordinate
So how
bench.
can you mention a matter without informing the other side?
Yes, yes.
Lordship, no service was done.
Yes, my lord.
Lordship, I
This
put
is
them to strict proof whether they have served me a
Yes,
notice or not.
It is admitted, my
Let
lord.
this
I have
matter
not-
be listed in the monthly list of February.
Lordship, in any manner, Lordship, I have instruction to that extent that the award has been passed. This appeal has become infructuous.
What has been passed?
Award has been passed. This appeal has become infructuous.
Learned counsel for the respondent.
Respondent, Your Lordship.
Respondent states that the final award has been passed. The present petition has become infructuous. The same is dismissed.
No award till date, my lord, they have
Much
not
obliged, Your
received any
Lordship.
award.
Lordship will hear it from me the basis of the
Award.
judgment.
If the award has already passed,
No.
I don't need to hear it. Sorry.
Lordship, we'll hear one
Much
moment.
obliged, Your
Lordship.
Lordship.
This
Yes.
award, if an award is passed, but this order was passed on the basis of a coordinate bench judgment passed by this honorable court. If Lordship is
When
disagreeing
you
with
want to be so fair to the court, then you should have served the other side also. All right?
Lordship,
Why you have not
let,
served them?
Yes, my lord.
keeps
That
it tomorrow. Let them
my fault, my
respond.
lord.
Keeps it tomorrow or any
you
other
mention
day.
it like this?
My lord, I have mentioned, my lord.
Why
without-
have you mentioned it?
Yes, my lord. I mentioned without.
Why?
My lord, interim order was not there. My lord, they have also not served anything. My lord, they have not filed any opposition, my lord. The direction was there. Twice, my lord, direction was
At the
extended.
request of the learned counsel of the parties, let this matter be listed tomorrow.
Yes, my lord. Several direction was given. Yes,
Be fair to the court.
I apologize, my lord. I apologize, my lord, because my lord, they have
Don't
not
try to
filed.
take this court for a ride.
Yes, my lord. That is my
And
fault.
you have a
That
face
is my
value.
fault.
I've seen you appearing in my court.
Yes, my lord. That is my fault.
I don't expect this from you.
Yes, my lord. That is my fault, my lord. I have not served any notice, my lord. They have not filed any opposition till date, my lord. So, my lord, I mentioned this matter.
2023.
Yes, my lord. They have not
The stay has been literally not been extended.
extended, my lord.
And then you come here and you mention the matter without informing the other side.
They have not served also filed an
You want to get
opposition,
an
my lord.
order.
2 times, my lord. Kindly see the 2
Our
orders.
fault, Lordship. Our fault. I bow
apologize.
down. Our fault.
I beg your
Absolutely unfair.
yes, that is I bow down, my lord. This is my fault, my lord. Not my counsel, my lord. This is my fault, my lord.
This is what it. This is absolutely unfair to the court.
Yes.
Your conduct is so unfair.
Yes.
Tomorrow.
Lordship, and
I'll come with a copy of
I'll
the
come
award.
with a copy of the award and also the proof of service stating that they have received the award.
I'll show those judgments, Lordship, passed by
obliged,
the
Your Lordship.
coordinate bench, Lordship, with regard to this unilateral appointment of arbitrator.
In any manner, if your Lordship
Kindly.
be pleased to keep the matter in the next week, we'll take some time to retrieve the
At the
documents.
request of the parties, let this matter be listed next week.
Much obliged, Your Lordship.
For the claimant petitioner, so this is the third application. In this matter, my lord, the first learned arbitrator, my lord, resigned. Then the second learned arbitrator appointed by this honorable court, my lord, he proceeded up to the stage of hearing. Hearing almost concluded, then he was elevated. We again approached, my lord, for substitution, my lord. Third arbitrator has been appointed. He is conducting the hearings. In the meantime, the mandate has expired.
Yes.
No objection. My lord, may I point out the
Yes. Just
appointment
give
of
the,
the
Mr. Banerjee give the appointment date.
appointment date, my lord, of the third arbitrator is the 29th of April 2025. But previously, my lord, it was done on 1st of December 2023, the second learned arbitrator. If your lordship kindly
The
come
first one was appointed in 21.
21.
What is the
during
date of
COVID
that?
period.
What is the date?
No, I'm giving the date. my lord.
March
22nd March 2021.
22nd March 2021.
Then, my lord, 1st of December 23 is the second learned arbitrator.
First of the order.
The period of limitation did not expire because of the judgment of the Honorable Apex Court till June 2022. Then 1 year and 6 months. Then the
Oh, this was extended earlier.
extended on the 22nd of April 24, first extension, 22nd April 24, first extension, page 195, and 19th November 24, second extension, page 244. Then it was almost complete. Then he could not deliver the judgment in the matter, so
He got elevated. All right. The
appointment is 246, third arbitrator.
appointment is page
246, the learned third arbitrator. And prior to that, the extension was on 19th November,
second volume then.
second volume. 244 is the last extension. 1 year.
Lordship, may I permit mention?
Yes.
At the same time.
Who's this? Why is it getting repeated? They should just said it here. It's all recorded, which is being played. It all happened in the court. Madam, fix the problem.
Repeat.
All right, take down. The present application has been filed under section 29A of the arbitration and the present application has been filed under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of conclusion of the arbitral proceedings and publication of the award, arbitral award, full stop. This, yeah, वास्तव बंद करो.
System volume ta কমিয়ে দিন.
Learned counsel for the petitioner, Mr. Ian Banerjee submits that this court, by order dated 22/3/2021, appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The respondent challenged the mandate of the arbitral tribunal under section 16 of the Act, the said challenge was dismissed with cost. Full stop. In the meantime, the statutory period of 12 months from the date from the date of completion of the pleadings expired on 28/2/2023. Since the respondent declined to grant consent for extension of the mandate, the petitioner approached this court under section 29A, full stop. By order dated 30/8/2023, the mandate of the arbitral tribunal was extended for a period of 6 months, full stop. Upon expiry of the extended period, the petitioner once again approached this court, full stop. The respondent contested the application, and by order dated 1/11/2023, this court substituted the arbitrator. This was the second appointment, right?
My lord, second appointment.
Full stop.
Page
The
191.
respondent challenged the said order before the Honorable Supreme Court in
There's been also kind of
SLP number. Where's the order of the SLP?
SLP lord possibly has not been annexed, lord.
What is the number? Oh, it's here. SLP number
I'll check.
210 of 2024, which came to be dismissed on 8/1/2024. Full stop. Since the mandate of the newly appointed arbitral tribunal was due to expire on 29/10/2024, the petitioner again moved for extension before this court by an order dated 22/4/2024, comma, this court extended the mandate by further for a period of 6 months till 21/10/2024, full stop. On a subsequent application, this court by order dated 19/11/2024 extended the mandate by 1 year, full stop. On 10/3/2025, the learned sole arbitrator was elevated to this court, comma, necessitating substitution under section 15 of the Act, full stop. Accordingly, by order dated 24/4/2025, a new arbitrator was appointed, full stop. The matter presently stands at the final stages of argument, full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal, full stop. The record indicates that multiple challenges were raised to the mandate of the arbitral tribunal, including proceedings carried up to Supreme Court, Honorable Supreme Court, full stop. The matter was required the matter also required substitution of an arbitrator on 2 occasions, full stop. The present arbitrator assumed charge only on 24/4/2025 and has conducted the arbitrator on 24/4/2025 and has conducted the arbitral proceedings.
So 29th April he was appointed. 29/4 he was appointed.
29/4, sorry, 29/4/2025 and has conducted the arbitral proceedings till date, and the same is at the stage of final arguments, full stop. Upon consideration of the entire record, comma, this court is satisfied that there has been no delay attributable to the learned sole arbitrator, full stop. There has been no undue or unwarranted delay on part of the learned sole arbitrator, full stop. Having regard to the advanced stage of the proceedings and in the interest of justice, comma, the mandate of the arbitral tribunal is further extended for a period of
6 months will be possible.
you need
Hearing, and he will
6
take
months.
some time for award.
6 months from today, full stop. The learned sole arbitrator is requested to make all reasonable endeavors to conclude the arbitral proceedings and publish the award within the extended period, full stop. With the above observation, the present petition is disposed of.
Much obliged.
Yeah, please, Lordship. Before my learned friend starts, Millets, I have not been served with a complete set of the paperwork. Moreover, Millets, even the prayer clause in the petition is missing. Today, I don't know whether he's seeking substitution or an extension. No pagination to the petition. These are disconnected matters.
Incorrect, my lord.
You may see that.
I do not know because, my lord, I have
incorrect
already,
Have you given a copy to him?
I have already served, my
This
lord.
is
My
appearing for the first time before Millets. And yesterday
Millets, the
evening
only
at
thing-
6:30 p.m., my client has been served. And thereafter, I was
if he
contacted.
wants to take a time, I won't stand in the way. Kindly keep it in some other day, my
I
lord.
did not come in the way for extension. I am the claimant.
Matter has not
Millets,
been called. My
I
learned friend is
just want to assess the honorable court. Today, I don't know whether it's an extension or a substitution.
It's an extension.
Let's let him serve a complete copy. Let it appear before Millets
give a copy.
tomorrow.
my lord, I'll give a
Both
copy.
the matters, Millets.
My lord, this is my affidavit of service, my lord.
Learned counsel for
My lord, both the matters, my lord.
states that he has not received a complete paper book. Let the same be supplied to the counsel for the respondent. Affidavit of service taken on record. Let this matter be listed
Tomorrow. Highly
My
grateful.
lord, the next matter is also identical matter.
Same order.
Grateful.
Highly grateful.
Lordship, this is my section 29A application, my lord.
Yes.
The arbitrator, my lord, was appointed on 29th April 2022. My lord,
Your Lordship, kindly takes my affidavit of opposition on record, Your Lordship.
Affidavit in opposition on your side, right?
Yes. Affidavit in opposition.
Lordship, the pleadings were
Your Lordship, before he starts, Your Lordship, I'm being led by Mr. Ishan Shah. If a date could be fixed for hearing, Your Lordship.
We can hear it today, madam.
Your Lordship, then
Yesterday also I told you this.
yes, Your Lordship, but since he's on his legs, if a
We'll pass it over.
kindly gives a passover, I'll take instructions, Your Lordship. Much obliged.
You're disputing.
Yes, Your Lordship, I am disputing because of the conduct of the claimant, Your Lordship. The conduct has not been bona fide, Your Lordship.
You know the scope of 29A.
I understand, Your Lordship.
Conduct is not going to play a very important role. Sorry. Not today. We'll have it tomorrow.
Much obliged, Your Lordship.
Tomorrow.
Lordship, if it may be kept next week, my lord.
Why?
Lordship, tomorrow I'm in some difficulty.
Not this week. Affidavit affidavit in opposition is taken on record. At the request of the learned counsel for the parties, let this matter be listed. Next week, the date.
My lord, in item number 10, I am appearing on behalf of the petitioner, your
Lords,
lordship.
I appear for the petitioner, my lords. I am appearing virtually. Lordship, this is my section 29A for extension of mandate, my lords.
Yes.
Of an arbitrator. Lords, the appointment was done by order dated 28th January 2023. That order, my lords, I have placed on record at page 13 of my petition. My lordship, the operative part of the order is, in fact, my lordships would recollect, this is a matter which was argued on the last date of hearing. My lordships, they filed their reply. It was argued for more than 40 minutes. I'm from Delhi. I came from Delhi to argue. Lordship said,
my lord, made it returnable, my lord. On the ground, my lord, one connected matter, my lord, is pending before the Honorable Supreme Court, where my lord, Supreme Court is my lord, yet to decide under section 29A, which will be the court, whether it will be my lord, section 11 court which has appointed the arbitrator, or it will be the court within the meaning of 2(1)(e). That's why my lord, your lordship, my lord, kept it pending, my lord.
So, my lordships, that matter is still, my lordships, insofar as that is concerned, my lordships, that the judgment is not out as yet. But, my lordships, I have placed on record 2 judgments. My learned friend is carrying 3 judgments, a compilation of 3 judgments. My lordships, in fact, this honorable court has decided the issue. My lordships, Justice Sarkar and Justice Bhattacharya, these are the 2 judgments, my lordships.
Bhattacharya will be against you. Justice Sarkar is in your favor, probably.
And your lordship has also decided in their favor.
In my favor, my lords. In fact, if my lordships, the ratio, if my lordships would have the index page, best, eastern, western, my lordships, the relevant paragraphs I've marked para 1, 16 to 27 and 45, 47. The High Court alone retains jurisdiction for the purpose of extension under section 29A, and the Commercial Court does not have any jurisdiction. So my lordships would see paragraph 1. This is an application at page 1. Under section 29A(4) of the ANC Act, the dispute arose of a partnership deed dated so-and-so. An application for appointment of an arbitrator was filed before the court-wide AP number so-and-so. A learned advocate bar library club was appointed as the sole arbitrator. The proceedings continued before the learned arbitrator. The period of 12 months from the date of completion expired on so-and-so. Thereafter, the parties consented to an extension of 6 months. The mandate of the learned counsel stood extended till so-and-so. Such extension of the consent of the parties had been recorded in the minutes. So in the present case also, my lords, there is a consent, that 6-month consent is there on a wide order dated 14th of February 2025, which my lordships would find at page, just a minute, at page 43, my lords. This is the order that I had read. The scope, my lordships, under section 29A is very limited. So, my lordships, this is a waiver. The mandate of the tribunal is extended.
What do you want? I have already taken a decision.
My lord, on
Either
the
I follow my decision or we wait for the outcome of the Supreme
Lord,
Court.
let us, my lord, wait for the decision. And here, my lord, fact is
Unnecessary.
also slightly different from the judgment which your lordship has decided. Because, my lord, here what has happened, arbitrator, learned arbitrator has been appointed by the Jalpaiguri bench, my lord.
That doesn't matter.
Yes, my lord, there is a, my lord, distinction of, so far as our roster of our court is concerned, my lord, that is, my lord, segregated. Determination is, my lord, segregated. In respect of, my lord, Jalpaiguri, in respect of Port Blair, and in respect of, my lord, the principal bench, my lord, determination is, my lord, segregated. So, my lord, they are, my lord, I have, my lord, taken, my lord, threefold objection, as I have, my lord, on the last occasion, my lord, pointed it out to your lordship. Initially, they have filed their Section 9 application before the district judge at Darjeeling, which, my lord, now has become the commercial court at Jalpaiguri. Thereafter, my lord, they have moved their application before the Jalpaiguri division of this honorable court, and the the learned arbitrator got appointed, my lord. Thereafter, my lord, we have filed an appeal under Section 37, which is, my lord, lodged at, my lord, commercial court at Jalpaiguri, my lord. So, and so far as the jurisdiction clause is concerned, my lord, I have shown to your lordship that is, my lord, very specific, that anything arising out of this agreement would be, my lord, subject to the jurisdiction of the court from which, my lord, that contract was not awarded, from the airport from which the contract was awarded. It is, my lord, there is, my lord, not a dispute that contract was awarded from the Bagdogra airport. Subject matter of the contract, that is for the purpose of running the restaurant, that has to be, my lord, performed at Bagdogra airport.
My learned friend is seeking to.
And, my lord, and surprisingly, my lord, they, my lord, themselves admitted, the honorable bench which, my lord, appointed the arbitrator, they did not have the jurisdiction. On the last occasion, my lord, they admitted itself. And if it is so, my lord, I am also, my lord, carrying judgment to show to your lordship, if an order has been made without jurisdiction, that order is void ab initio, and I can take up that point, my lord, at any stage, be it in execution proceedings, be it in, my lord, collateral proceedings, and be it in, my lord, any other proceedings. And our court, my lord, has consistently held that.
Lordships,
I would request, my lord, let the, my lord, Supreme Court judgment come, my lord, then, my lord, we can, my lord, put an end to
tactic, my lords,
all the
because I am the
controversy.
claimant, my lordships. I have suffered over there. My lordships, the very third judgment. In fact, the Honorable Supreme Court very recently, last week, my lordships, has come out with a judgment that there is no appeal, my lordships, against an order. My learned friend is seeking to now. He is saying that the appointment itself is bad. Having participated, there is no Section 14, no Section 15 application, my lordships, and the scope of these proceedings are very limited. My lordships is very well aware. They have consented, my lordships, and it also constitutes a waiver if my lordships would have the third judgment of Hindustan Construction. So they cannot now say that. So my lordships would have page 34, it starts, and my lordships would have the relevant paragraph 5. My lordships, contentions of the parties at page 37. The learned senior counsel for the appellant submitted that the High Court exceeded its jurisdiction, passing the impugned judgment dated so and so, thereby reviewing its earlier order dated so and so, passed under Section 11(6) of the ANC Act, by which a sole arbitrator had been appointed. That order had attained finality, having never been challenged by the respondents through any appeal or other proceedings. Moreover, the ANC Act is a self-contained act, and does not confer any power of review upon the High Court. Hence, the very act of entertaining a review petition was without jurisdiction. And second, my lordships, the point that I'm trying to make is there is a waiver, my lords. There's in fact an express waiver where there is a consent recorded for consenting, my lordships, to continue before the learned arbitrator for 6 months. And my lordships, today they cannot say that my lordships, the arbitrator should not continue, having consented for 6 months. Today, my lordships, what is the stage of the case? The pleadings are complete. The trial has concluded. Arguments, my lordships, I have mostly concluded my arguments. It is just for their arguments, and in fact written submissions are also filed. It is just for an award, my lords. Today they are shirking away this, my lordships, their conduct also, my lordships. I have prepared a short note. My lordships would take that short note on record. My learned friend can hand over the copy of the short note along with these judgments. My lordships may decide this matter. There is no use of waiting. Today, my lordships, the law is, my lordships, very clear that my lordships, in fact, the first two judgments that the appointment, the court which appointed the arbitrator, my lordships, not the commercial court, my lordships, which can sit over the High Court to now, my lordships, decide whether the mandate has to be extended or the arbitrator has to be substituted, my lords. That is the law as on date, my lords. So my lordships may take the note on record and my lordships may consider these judgments. And my lordships, I pray my lordships that the petition be allowed and a mandate of for 6 months, my lordships. He should, the learned
You
arbitrator.
want to deal with his submissions or you don't want to deal with his submissions? He has submissions, sir. Mr. Bhalla, you want to deal with his submissions or you don't want to deal with his submissions?
I have dealt, my lords. These are the judgments, my lordships, insofar. So, my lordships, his contentions are twofold. One, whether the commercial code.
Let's hear him.
All right.
This is all your argument, nothing more?
Nothing more, my lords.
All right. Yes.
No. Kindly, my lord, takes up, my lord, their application. Now, kindly comes to, my lord, page 13 of their application. That's the, my lord, order, my lord, appointing, my lord, the learned arbitrator. In the High Court at Calcutta, Circuit Bench at Jalpaiguri, Civil Revision and Jurisdiction.
Page 30.
Page 13, my lord.
By consent of the parties. What are you reading? This is the
Page 13 of, my lord, their application, my lord.
13.
13, my lord, Annexure A.
Yes.
In the High Court at Calcutta, Circuit Bench at Jalpaiguri, Civil Revision and Jurisdiction Appellate Site. Then, my lord, the nomenclature of the, my lord, petition is CO 66 of 2022.
Yes.
My lord, by virtue of this order, the Honorable Bench at, my lord, Jalpaiguri has appointed the arbitrator. My lord, when they, my lord, moved this application, they themselves said, I am going by, my lord, their submission. They themselves, my lord, made submission before this honorable court saying that Jalpaiguri court, the honorable Jalpaiguri bench would not have the jurisdiction to make an appointment under section 11. That was, my lord, their, my lord, submission. My lord, I will come to that, whether, my lord, that court had the, my lord, jurisdiction to appoint the arbitrator or not. I will, my lord, come to that part later. My lord, let us assume this honorable Jalpaiguri bench has appointed this. Now, my lord, before that, preceding this before this application has been made before the honorable Jalpaiguri bench, my lord, I have, my lord, indicated in my affidavit in opposition, they have, my lord, moved an section 9 application. That was, my lord, filed in before the Court of Learned District Judge at Darjeeling. Now, kindly comes to page 26 of my affidavit in opposition. It is one of their section 9 application. Page 26, my lord. And they have, my lord, not used any affidavit in reply, controverting the facts that have, my lord, brought into by way of this affidavit. Page 26, my lord, it is their application in the Court of Learned District Judge at Darjeeling. Director of Amazing India Contractors versus Airport Director, Bagdogra, Customs Airport. Petition under section 9 of the Arbitration and Conciliation Act, interim measures by the court. Now, this application gets dismissed on 17/5/2022. That would, your lordship would find at page 31. So, my lord, it is them, my lord, who has approached the court within the meaning of, my lord, 21E at Darjeeling. They are the first one to, my lord, approach. And thereafter, my lord, I would also show from page 35 onwards, your lordship would find we have also, my lord, approached the commercial court at Jalpaiguri, which was, my lord, jurisdiction of whose was, my lord, previously vested with the Learned District Judge at Darjeeling. That, my lord, to transfer to the commercial court at Jalpaiguri. we have also filed an appeal under section 37.
Yes.
So, my lord, for the purpose of 21E, read with section 42 of the Arbitration and Constitution Act, my lord, it is, my lord, our contention that this would be the court should be in whose jurisdiction, my lord, they have, my lord, approached first. And, my lord, this is, my lord, also supported by the fact, if your lordship, my lord, kindly takes up the jurisdiction clause, that is at, my lord, page 20. Page 20, my lord, clause 30.
Yes.
In case of any dispute where legal action is compelled to be initiated by any of the party, jurisdiction of the court shall be the city, town, district where the airport is located. And, my lord, from the contract I can show to your lordship, it is the Bagdogra airport who has not entered into the contract. The performance of the contract, that is running of the restaurant, would, my lord, take place at, my lord, Bagdogra airport. So there is, my lord, no dispute with respect to that. So now, my lord, if I, my lord, go by the judgments which, my lord, as, my lord, I would go by the judgment which has your lordship, my lord, rendered in the case of, my lord, the India Private Limited versus Bharat Electrics Limited, and your lordship, my lord, has referred to all the judgments which, my lord, my learned friend is, my lord, relying on. My lord, so far as your lordship judgment is, my lord, concerned, factually, my lord, one difference is there in that section 29 application. Your lordship has the, my lord, privilege to see the order of principal bench. There, my lord, arbitrator was, my lord, appointed by the principal bench, which is, my lord, having determination under section 11. So your lord, my lord, so far as that judgment is concerned, I would be bound to that extent. Had, my lord, in this case, principal bench appointed the learned arbitrator.
Why don't you challenge the arbitrator's mandate?
My lord, so far as arbitrator's mandate is concerned, so far as this question of jurisdiction, I, my lord, came to know from them after, my lord, their submission. And, my lord, I can, my lord,
participating in the proceedings.
Now, my lord, what I can show,
This is listed at the final stages.
now, my lord, what I can show, there are judgment of Honorable Supreme Court and our High Court. They have, I would place those judgments to show.
No, I'm asking you, sir, why didn't you raise all these points? You could have challenged the mandate of the arbitrator.
My lord, I'm coming to that. I'm answering that one. I would not, I was,
Say
my
you're
lord,
opposing
lord,
section
after they,
29A application, which is
after
just
they
an
have,
extension.
after they have filed the application,
Yes.
and it is them who has pointed it out in response to my argument that it should have been filed in Jalpaiguri court.
So they have given you the idea, now you're harping on it.
Yes, now, my lord, because, my lord, law authorizes me to do so. Because I would, my lord, argue, if
So
there is
law authorizes you, when did they give you this idea? You have moved an application.
no, my lord. But after the, my lord, mandate has expired, that application is that when this application was being heard, my lord, being heard, that time, my lord.
That time they gave you the idea.
Yes, my lord. They submit, my lord. Kindly ask them, my lord. They are the one who has submitted. Now, my lord, what I can show to your lordship, I can place before your lordship. So far as waiver is concerned, if a court does not have jurisdiction, then no amount of consent also can, my lord, can confer jurisdiction. This is, my lord, number one. Number two, so far as question of jurisdiction is concerned, irrespective of the fact, if I have not taken in that particular proceedings, I can take it in execution. I can take it wherever I want to assert my right. That has, that was the, my lord, view of the Honorable Supreme Court and Division Bench of our High Court.
Sure, ma'am. In an arbitration proceeding,
My lord, I have already given the judgment your lordship must be having. Which one? Garden Bridge Shipfood Engineers Limited, Marine Craft Engineers Private Limited. Your lordship is having out there.
yes.
I'm due. I'm 2025 STC.
Yes.
Yes, not. Scale 607. My lord, kindly come to page para 36. It is therefore clear that on both the aforesaid dates, when the said honorable judge, who has passed the order impugned, took up the matter for adjudication for the first time, and when the matter was marked heard in part by the said honorable judge, the said honorable judge had determination only over such application under section 34 of the said Act 1996, which did not pertain relate to commercial matters. Determination in respect of all arbitration application, including those under section 34 of the said Act 1996, as spelled out in section 10 of the Commercial Court Act 2015 extracted herein, rested with the another honorable judge of this court in terms of the roster dated November 14, 2019. The Number para 38. The date of reserving judgment, that is March 31st, 2023, as on the delivery of the judgment, that is April 5, 2023, the said honorable judge had the following determination in respect of the original site. Matters motion and hearing under Article 226 of the Constitution of India relating to Restitutory Group 9, including application connected thereto 2017 onwards.
Where do you get this from, that the circuit judge didn't have the power to appoint an arbitrator?
No, they said, no, not. It is not they.
Mr. Balla, have you said that?
My lordships, I haven't said. I have said that they cannot extend the mandate, my lords.
No, Jalpaiguri
My lordships, because the section 29A, for the purpose of section 29A, they will not be having the power, my lords. That is, my lordships, because
You only said 29A, not about appointment of the arbitrator.
They
Today, I don't have the power to appoint the arbitrator. That is with another bench. They have never said that.
Yes.
On the last occasion, they said that the arbitrator could not do.
No, they are saying that they don't have the power under 29A to extend it. They are not saying that the appointment power is not.
Then, my lordships would say determination to check that.
Can you pull out the determination? You are making a
then I have to pull out the
submission
determination.
in thin air. There is nothing on record to
They
substantiate.
themselves will not said that.
They are saying they have not said it.
They have then they not have to pull out the determination.
So then I dismiss it. Then I extend the mandate.
Yes.
Then in terms of the orders passed by this court, we'll extend the mandate.
Lordship, may in that case, may I
don't have anything on record to
your
say
lordship
that.
to
This
wait.
is not even part of your affidavit in opposition.
My lord, may I?
Where have you raised it?
My lord, may I request your lordship to kindly wait till the Supreme
Why?
Court delivers?
There's a view which has been taken by this court. We'll extend that view. Whatever will be the outcome, we'll see that.
And my lordships, today they are seeking
Factor is not
mandate of the
this
arbitrator.
principal bench has not, my lord.
We have taken a view. We'll go by our
My
view.
lord, your lordship has definitely not taken a view, my
We'll
lord.
go by our view.
What I am on is, my lord, in that case, my lord, the principal bench has, my lord, appointed the arbitrator.
Sir, whatever it is.
So
Today
then, my
you
lord,
you don't have anything. They have not made the statement. The argument which is advanced by you is not.
No, my lord. That was, my lord, with respect to, my lord, whether the jurisdiction of the arbitrator to continue with the matter. That was, my lord, my secondary
All right,
submission.
take down. The present application has been filed by the petitioner under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the arbitral proceedings and for publication of the arbitral award. Full stop. This court-wide order dated 28/6/2023 appointed the arbitral tribunal to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 11/3/2024. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months. Full stop. The mandate of the arbitral tribunal has expired on 10/9/2025. Full stop. The matter is at the learned counsel for the petitioner states that the matter is at the stage of final arguments. Full stop. Hence, the petitioner has preferred the present petition seeking extension of the mandate of the arbitral tribunal by 6 months. Full stop. Learned counsel for the respondent opposes the present petition on the ground that the arbitral tribunal has been appointed without any jurisdiction. He has no facts to substantiate such argument. The arbitrator was duly appointed by this court by order dated 28/6/2023. Full stop. The said contention has never been raised by the learned counsel for the respondent. Full stop. He states that he has picked up this argument from the stand of the petitioner, wherein they had stated that the circuit bench at Jalpaiguri has no power to extend the mandate of the arbitral tribunal, full stop. He has mistakenly construed that even for the purposes of appointment of the arbitrator, and states that the circuit bench at Jalpaiguri had no power to appoint the said arbitrator, full stop. The said fact has never been pleaded in the affidavit in opposition. Neither the respondent has any ground to substantiate such contention, full stop. This court in its earlier occasion, the other ground taken by the learned counsel for the respondent is that the court of original jurisdiction in terms of section 2(1)(e) would be the commercial court at Jalpaiguri, full stop. Though this court has consistently held in various judicial pronouncement, recent being, where's my judgment? So and so, that in the case where the appointment has been done by the High Court, the mandate for extension of the arbitral tribunal under section 29A shall rest with the High Court. In AP Com 673 of 2025, the Indore Private Limited versus Bharat Heavy Electricals Limited. ये कोट कर देना, ठीक है. In view of the said proposition, this court is inclined to.
I have one subject to your lordship.
Yes.
I have also indicated one distinguishing factor. Lordship, kindly record that.
What distinguishing?
That principal bench.
उससे पहले लिख देना. Learned counsel for the respondent has also stated that the petitioner had approached the commercial court at Darjeeling. Initially, the petitioner had approached the commercial court at Darjeeling.
District judge at Darjeeling, which became
district judge at Darjeeling under section 9 of the Arbitration and Conciliation Act, and thus the court of original jurisdiction would be Darjeeling. Full stop. उसके बाद ये कर देना.
Here also in your lordship judgment also, the principal bench not appointed, and they are not in our.
I have already recorded your the Jalpaiguri bench.
Subject to correction by your lordship, I have not submitted that the judgment which your lordship has delivered. In that judgment, principal bench of this court appointed the arbitrator. Wherever the case in the instant case.
Sir, I have dealt with that. Your argument to that extent that you are challenging the mandate also on the ground that the arbitrator has been appointed by the circuit bench at Jalpaiguri.
My lord, kindly, my lord. With your lordship, my lord, kindly, my lord.
Application allowed.
Lordship's mandate for 6 months from today.
Not extended for a period of stay of this operation of this order, my lord.
Not at all. Should this order be stayed?
They just want to delay, my lordships, the conduct, my lordships, and the matter.
I can see their conduct.
Yes.
Great, my lord.
For 6 months, my lords, from today?
6 months.
All right. Thank you. Extremely grateful, my lords.
May it please your lordship. On the last occasion, Mr. Gupta was continuing his arguments. May I continue till such time he arrives? The issues that I'm sorry. Now, just to give a very brief recap, because your lordship must have had 200, 300 matters in between. A, the issue was jurisdiction. That the arbitration clause said the venue would be at Bhubaneswar. So that is one of the points taken. The second point taken is that I'm sorry.
There's a judgment of the Honorable Supreme Court regarding this venue and seat.
Yes, which my learned friend had placed,
Yes.
possibly.
I placed it in my compilation, your
Yeah,
lordship.
please.
Yes.
I have placed it.
And that is completely inapplicable in our facts, and I shall tell you lordship why. before I go into my learned friend's judgments, my lord, just to conclude on the facts,
I didn't
no,
want.
I will have to, my lord, deal with that.
Yeah, but I didn't want to. I was just saying that,
Yes, but I would have to deal with all the judgments. My lord, on the last occasion, my lord, I had indicated.
I didn't want to break your momentum of
No,
argument, Mr.
no, your lordship has always.
No, I don't want to do that. It was just that I was indicating.
Yes.
That now the issue of the seat and venue.
Yes.
Is pretty much clear.
Pretty much
in
clear.
terms of
Yes,
the Supreme Court. That was the only observation I had. Yes.
And because of that clarity, my lord, I say that I shouldn't be having a problem. So, my lord, I'll indicate why. My lord, on the last occasion, my lord, I had concluded my submissions for that day, my lord, by placing the issue of interest. Because, my lord, your lordship would kindly note the agreement does not provide for any interest at all. There is no bar of payment of any interest either. In none of my documents or my pleadings have I admitted to payment of any interest. In that event, my lord, possibly in a 31(6) application, which is really in the nature which they had filed, was a judgment upon admission in the nature of that. Whether the arbitral tribunal ought to have awaited for the trial to award the interest, or whether the arbitral tribunal was correct in granting interest straight away when there was no agreement between the parties. So, my lord, I am fully conscious to the position in law under the Arbitration Conciliation Act, Section 31(7), which says that the arbitral tribunal can grant interest. I am not joining issues with. I am not saying the arbitral tribunal could not have, but whether it was at that stage or whether it should have awaited trial, that is what issue, my lord, is. That is one of the issues which I, my lord, urged, my lord. Because in judgment upon admission, my lord, whenever your lordship's courts deal with any suit or anything akin to that, your lordships only look into the admitted amount, passes a part decree, relegates the balance claim or the claim of interest, as the case may be, to suit. Here, that has not been done. And, my lord, that is one side of the story. The other issue is, we had indicated to them that this is the amount which we think would be outstanding. Please come for reconciliation and so that we can pay. They did not come forward. So, on those set of facts, whether my interest liability would accrue from that date, when I had already offered them to come for a reconciliation and said that once that is done, we shall, or whether, my lord, we should be slapped with from that day, or whether, my lord, my liability to pay interest would have stopped on that amount. Balance amount, I am not joining any issues. But on that amount, when we have already said that you come for the reconciliation, having given the quantum, whether, my lord, that was a factor which the arbitrator should have considered.
How much can this court get into these things?
In a 34. In a 30, yes.
That you have to show.
I'll have to satisfy that, because unless there's a patent illegality or a gross perversity under the 34 and the judgments which really narrows the scope.
Because earlier we could.
Yes, it's really not an appeal now. So
earlier we could, and we would always interfere as far as interest is
but
concerned.
now after the Sangyong and those line of judgments, my lord, whether that would be a purpose. Yes, my lord, to that, my lord, may I just indicate one thing? Kindly takes a look at the 5th volume, the award, my lord.
Award dekana.
George Saab ke 5th or 1st volume ta dega?
5th volume and 1st.
5th volume and 1st volume. Well, just to show, for the completeness of my arguments, that the contract did not provide for, my lord, any interest, kindly takes a look at the 1st volume. In fact, your lordship will not find, my lord, the interest is not there. Your lordship need not be troubled with. Subject to correction by my learned friend, the contract does not provide for payment of interest, neither does it bars payment of interest. So that is the position. So, my lord, and the law is clear that, my lord, if the contract is silent and does not bar, the arbitral tribunal can. I am not joining any issues with that either. Now, on these facts, kindly takes a look at the volume, the 5th volume of the award. But I was placing from the internal page numbers, the reference.
Yes.
My lord, will kindly have a look at, my lord, internal page 31, my lord.
Yes.
Now, there's a paragraph
Now the payment of interest.
Now the payment, yes. Great.
Yes.
Now the payment of interest per se pendentility and post-award period till the date of payment as claimed by the claimant is to be considered by this tribunal. Mr. Such and such learned counsel submitted that there is no clause in the contract for payment of interest, therefore cannot claim interest award. According to him, by email dated such and such, the respondent offered the claimant for payment, but the claimant did not pay any heed to it. Therefore, the claimant cannot get any interest as claimed. He also cited some judgments in support of his contentions. My lord, we had placed judgments on. May I pause here for a moment?
Yes.
We had placed judgments on the issue that if there is a valid tender, then the interest obligation would stop if they have not accepted that. But none of these judgments find any reference. None of these judgments have been dealt with. So that is one of my contentions that this award is against the fundamental policy of Indian law. I have placed judgments on a particular proposition. Those judgments have neither been noted nor been dealt with. May I not even refer to in the award. Now the next line, I'm sorry. Mr. Sajjan Sach referred section 31(7)(a) of the Arbitration Conciliation Act and submitted that the tribunal is authorized and competent to award interest. He also submitted that even in cases where no such provision was there, the honorable courts awarded interest under the Interest Act. He further submitted that the honorable courts allowed interest on consideration that a party prevented to utilize the money and earn profit specifically in commercial transaction should get interest. He cited several judgments in support of his submission. This is a well-settled principle, and as such, there is no necessity to refer to judgments in that regard. There is no doubt that both the parties are engaged in business and were doing business. Here, the claimant being awardee entitled to get amount as admitted, and they have been paid the amount as per clause of contract, they could have utilized the money in trade or business, which they were prevented. Accordingly, I do not find any substance in the submission of such and such. That is all. That is all on interest. So whether the issue of the valid tender was not even considered, that the only submissions were recorded. There is no consideration at all, which is a perversity. And your lordship would find in the next page.
But he says that the judgment cited by Mr. Gupta delivered in different sets of facts, and he didn't quote the judgments, but
yes, but none of the judgments, and on the issue of valid tender also it was not considered, that whether that document amounted to a valid tender or not. That issue has not even been dealt with. Only submissions were recorded.
you filed your written submissions also here.
Yes.
Along with the judgment.
Yes.
All right.
Now, my lord, we'll kindly turn to the next page. In fact, the last line of that page, therefore I do not want to refer the judgments relied upon by the counsel for both the sides. Since I have passed interim award, allowing such and such, and the conciliation, in my opinion, the claimant is entitled to get simple interest at the rate of such and such. Accordingly, the claimant prayer for interest is allowed, the respondent directed to pay interest on such and such. This is from the date of that document. So, my lord, this really deals with 2 or 3 issues. Not A, the issue of valid tender has not been considered at all. B, there is no admission as to interest. So whether at that stage, could the arbitrator, if I may argue in a question format, could the arbitrator have granted interest at that stage without awaiting for the trial on the interest issue? Because the other claims are there, the trial is going on. This is only a part. So whether the arbitral tribunal, whether it was proper for the tribunal to grant interest at that stage. That is one of the issues, which in my humble understanding, possibly the arbitrator should have waited for the trial on that issue.
Yes.
Now, my lord, one of the
The final award has been passed.
No.
Trial is concluded, it is pending for final.
Final.
No, the arbitration is stayed now.
Final argument.
The arbitration is stayed.
Yes.
Now, my lord, your lordship would recollect, my lord, on the last occasion I had submitted one of my major, my lord, points in the section 34 is consideration of the 31(6) prior to my amendment application. Because that, my lord, I had placed the judgments on that a amendment application has to be considered prior to any other application, even if for demurrer. Because the objective of the court is always to, my lord, allow that amendment or disallow and then consider the other applications. My lord, how the thing spanned was that, my lord, the arbitrator, and I had shown from the award also, considers 31(6), and really because I have considered that issue is answered, so the amendment is now redundant. This is what is being. So, my lord, the entire, my lord, if I may use the term expression, my lord, this is the fundamental policy of Indian law which is being violated here. Because, my lord, when the arbitrator proceeds to consider my amendment on the ground that I have already awarded in the interim, that is, my lord, possibly it's judicial impropriety, possibly, subject to your lordship testing it, of course. And now, one of the, my lord, arguments which my learned friend had, my lord, advanced, and I can see that from the tenor of the judgment cited by him, that, my lord, an admission cannot be withdrawn. So the arbitrator was right in disallowing the amendment because we were trying to resile from an admission, sum and substance of their argument. And the second plank is, in fact, this is the second plank. The first plank is the contract is clear. So you cannot interpret anything, divorce the contract. So an amendment to such effect should not be permitted. So these are the two submissions on the amendment. Now kindly takes a look at my amendment application. That is at volume 3. That is at volume 3. It starts from page 464. I'm sorry, my lord. I'm sorry. That is volume 4. I'm sorry. That is volume 4.
Volume 4.
Volume 4.
Page.
কোনটা দেখাবো?
Mr. Gupta, page.
Yes, my lord. Only kindly sees volume 4. Kindly sees the 31(6) first. Page 465.
Which page? Sorry.
Yes. Page 465. There's section 31(6) application. My lord, kindly takes a look at page 475. 475. Paragraph 10. The respondent in its statement of defense has duly admitted the fact that there is a supplied a deficient quantity such and such. Then again, my lord, your lordship would kindly have a look at page 476. Again, my lord, paragraph 12 is based on the averment in the statement of defense.
Yes.
Now, my lord, paragraph 13 at page 476.
Yes.
They rely on that annexure, that email your lordship would recollect, where there are two tables, my lord, where we had admitted, according to them, an amount of rupees such and such, 40 lakhs odd. That is paragraph 13 of the 31(6) application. These pleadings relate to the first contract. For the second contract, my lord, similar pleadings are there.
Yes.
So, my lord, they base their 31(6) application on the basis of my pleading in the statement of defense as well as that annexure G. And the prayers, my lord, will find at page 486. My lord, prayer A is in respect of the first contract. Prayer B is in respect of the second contract. Now, my lord, immediately thereafter, we file, my lord, the amendment application, which your lordship would find at page 362, third volume. Kindly sees what is the nature of amendments which we had sought for. And whether it is really, my lord, resiling from admissions or whether it's really explaining that document, that annexure G. Note 367.
Yes.
Note we had mentioned that in paragraph 3 that there are three mistakes which we discovered. Kindly sees A in paragraph 3M appearing at page 7. Has your lordship got it? Page 367. 3A in paragraph 3M.
যে রাখার বন্দোবস্ত করেছে আমাদের গাড়িটা ঢুকিয়েছেন শুনছি না রাজীব বাবুর গাড়ি ঢুকেছে গাড়ি লাগানো আছে আরে বাবা
Yes.
In paragraph 3A,
this is a normal thing. We don't get disturbed. Every day.
your lordships are made of different metal.
Every day, is, if you are here, every day you'll see this happening. Yes.
And there are a lot of other exciting videos also which does the round.
That keeps us entertained.
Yes.
Yes.
In paragraph 3M, appearing at page 7 of the statement of claim, the amount of ash content aggregates has been erroneously mentioned as such and such in place of such and such. Then again, the next also be, instead of 22 lakhs, it should be 20 lakh 96.
There's a huge disparity in this.
Yes, so 1 lakh 31 should be 24,000. And 22 lakhs should be 20 lakh 96,000. But the quantum is not much. The quantum is not much, Milord. Now, Milord, the C is with regard to one annexure which got, Milord, missed out. Now, Milord, we had indicated in paragraph 4 that these errors in the figures were clerical errors, as in page 50 of my statement of defense, we had already given the correct figure. But in the paragraph, what we had done is, in a schedule, we had indicated the correct figure. That is already there in the statement of defense. But in the paragraph, the component has come otherwise. So, my lord, the amendments which we have sought is page 369, paragraph 6A to C. Only these three.
Yeah.
There is nothing else. So, my lord, it is really not that we are trying to resile from any categoric admission which we had made. What at best this can be is we are explaining a figure which was there in annexure G. Now, to satisfy your lordship's conscience that these figures were already there, the correct figures were already there. Just to recap, I had placed that from the statement of defense, that chart I had placed. So those were already there, but in the body it had come down wrongly. And I had also placed annexure G to my statement of defense, which was the initial email you giving the figure, asking for reconciliation. We had tried to explain that whether it should be 10.613 ash content and the penalty should be on 61.613, or whether the tolerance of my 0.5 should be deducted from that should be 113. But if in my humble submission, this would possibly not be of that grave a nature that would disentitle me from these amendments. And I had also placed that the arbitration clause also contemplates arbitration on interpretation of the contract as well. On the last occasion, I had placed from that clause the wordings of that clause. Now, in these facts, kindly takes a look at their compilation, which they had cited. But since I was lastly dealing with admissions, may I straight away beseech your lordship to kindly take a look at. Kindly takes a look at their judgment at page 141. That is serial number 5 of their compilation. That is at page 141.
Although this judgment is there in the compilation, I had not read this judgment before this honorable court. Let me just clarify this. Otherwise, they can read it out. There's no problem.
You're helping them? Yes.
No, you would be relying on this, right? I had not read it in my opening submissions, but let him. I had not read this judgment, although it is there in the compilation.
So he's not using it for his arguments. You can if it supports you.
No, I would
have to give a contrary.
I would only want to distinguish.
Differentiate it, so I just want to point it out. I had not read it before the honorable court.
But I leave it to your lordship. If he places in the reply, I can also.
He's not placing reliance on it.
So I will deal with, if he places, I will deal with it in my reply. But what all judgments have you cited? Only on jurisdiction?
I have not cited this. Otherwise, I have gone through the other cases.
Only this you have not?
No,
Okay, very.
I'm just
very
lessening your burden.
Very good. Not a problem. Thank you. The we'll see. Just follow me. Kindly takes a look at page 152 then.
Yes.
Yes. Kindly takes a look at paragraph T at page 152. But before I take your lordship to the paragraph, just in a nutshell, what this judgment was, this was a partition suit filed by the plaintiff for partition of 10 immovable properties. The defendants filed written statements admitting jointness in respect of certain properties. On that basis, issues were framed that those are joint properties, so no issues on that. An application for receiver was made by the plaintiff in respect of the admitted properties which were joint. After 18 months from filing of that application, the defendant takes out an application for amendment saying, I have inadvertently, due to I was ill, I could not give proper instructions to my lawyer, I had wrongly admitted a few to be joint properties. In these facts, the trial court had dismissed the amendment application. The High Court in revisional jurisdiction allowed the amendment application, which was reversed by the Honorable Supreme Court saying admissions can't be withdrawn. So the facts in our case are completely different from this. Kindly I'll trouble you also with 3 portions of 3 paragraphs. Firstly, paragraph 3. The plaintiff had filed a civil suit for partition of 10 immovable properties. Then my lord will kindly turn the page to the second line of page 153. On the basis of my pleading in the state. The second line, the contesting respondent numbers 1, 2, and 3 who are defendant numbers 1 and 2 in the suit, being real brothers of the plaintiff, filed a joint written statement on 1st October such and such. In the written statement, a definite stand was taken by the contesting defendants that out of the listed properties in Schedule A, only 3 properties at item number such and such were exclusively belonging to the contesting defendants and were not joint family properties of the plaintiff and the defendant numbers 1 and 2. Meaning thereby that the other 7 properties listed in Schedule A were admitted to be joint properties. Not only that, but in paragraph 11 of the written statement, it was submitted that the plaintiff is only entitled for partition regarding the properties of Schedule A except in items 4, 9 and 10 and all the properties mentioned in Schedule B. They also stated in the said paragraph of the written statement that so far as admitted properties are concerned, the plaintiff was entitled to 1/3 share and remaining 2/3 share belonging to the defendant. It appears that therefore, thereafter the suit remained pending for trial. On the basis thereof, when issues were framed, the issue is quoted there. Then paragraph 4, obviously the issue was framed in light of the admission of the contesting defendants in the written statements that the rest of the items listed in Schedule A were joint properties where the plaintiff had a share along with the defendants. Then paragraph 5, in light of the aforesaid admitted position between the parties qua these properties, the plaintiff moved an application for appointment of receiver in connection with 7 admitted properties in Schedule A. It was at such stage, and that too after passage of about 18 months from moving of such application for appointment of receiver by the plaintiff, that the defendant number 1 came forward with an amendment application to amend his written statement. But in the written statement, if I may pause here with my lord's kind indulgence, in our written statement, and then your lordship would see, I'm sorry, then your lordship would see the amendment was dismissed by the trial court, reversed by the High Court, and finally, the Honorable Supreme Court set aside the order of the High Court, restoring the trial court order, saying amendments could not have been done because withdrawal of admission. But in our counter statement, statement of defense, we had
facts are different.
And we had all along contested this case. So one portion culling out saying that is an admission, but that in my humble understanding could not have been done. So this is with regard to this issue. Now, the other issue is on the issue of jurisdiction. Now, kindly takes a look at the rules of the Indian Council, Indian Chamber of Commerce, and I had placed also on the last day, but since I would be arguing on the jurisdiction point, page 17, page number is at the bottom, clause rule 30. May I place it, Page 17, page number is at the bottom right. Rule 30, place of arbitration. The place or venue of arbitration shall be Kolkata. May I pause here for a moment? These judgments say that if there is a designated venue and no seat is mentioned, unless contrary intention appears from anywhere else, only then would that venue be held to be the seat. In both the judgments relied upon by my learned friend, there was no contrary intention with regard to either the seat or the place of arbitration. The only wording was the venue of arbitration would be at X. Similarly, in our agreement also, it says that the arbitration would be done as per the ICC rules. The next line is that the venue would be at Bhubaneswar. So, this is the contrary intention, which is the place of arbitration. This is the seat. That is only a venue. But if no distinction is given on the venue or the seat, then venue may partake the character of a seat. But here, if the arbitration is going as per the rules, the arbitral tribunal has been appointed by ICC. It is being held at ICC's. It's held as per ICC rules. So, this clause, there is no section 11, nothing. It's ICC appointed arbitration. ICC appointed schedule.
No, but then we will give precedence to the.
That will give precedence to the contract. And in any event, whether precedence or not, the contract merely restricts to the terminology. The venue of the arbitration would be at Bhubaneswar. That's it. This is the contrary intention. This is the contrary clause, that the place or venue of arbitration shall be Kolkata. However, the council, having regard to the convenience of the arbitrators and the parties, may determine the venue and hold the proceedings at such place or places in India. But now, factually, what had happened? The contract said Bhubaneswar. The first sitting was held in Kolkata, RCC arbitration, at the ICC's office. There, the parties have agreed that till the completion of pleadings, let it go. When the witness action would be done, alternate sittings would be held in Delhi and Calcutta. When their witness would be cross-examined, we would be going to Delhi. When our witness would be cross-examined, they would be coming to Calcutta. So this is what the agreement was. So that really takes it neither here nor there.
This may not be factually correct because
That's all right. You'll get.
I just wanted to clarify.
Alternative sittings. 31-6. The alternative sittings were alternate sittings, not alternative. Alternate sittings would be held. So Bhubaneswar was given a complete go by both the parties. So venue, if at all there was one, was given a go by both the parties. Now, my learned friend had also, I don't know whether it's placed, but there are judgments from which I can say that they would contend that there had to be an agreement in writing to shift the seat. That had never happened. So this consent of alternate sittings elsewhere would not amount to shifting of that. So it continues to be Bhubaneswar. In my humble submission, this argument of theirs would be going against them. There is no agreement between the parties to shift it out of Kolkata. The place of arbitration is Kolkata. The venue is Kolkata. Arbitration sittings have never been held in Bhubaneswar. So that clause have been given a go by. So in these facts, kindly now consider the judgment of the two Supreme Court judgments which they placed reliance on. Compilation does other side. Compilation. But we'll kindly have a look at the first judgment. BGS Soma. Well, this is widely cited. Now kindly takes a look at page 28 of the compilation, the running page 28. I'll trouble your lordship with only that clause of the contract once. Kindly sees clause 6. Arbitration proceedings shall be held at New Delhi / Faridabad, India, and the language of the proceedings such and such. So there is no seat mentioned, no venue mentioned, anything. It only says arbitration proceedings shall be held at New Delhi. There is no other contrary clause with regard to seat or venue or place of arbitration in this contract. Now, kindly comes to page 70.
But this is explicit.
This is explicit in our case. Now, why the court said that the venue would partake a character of a seat in this judgment, which my learned friend was relying upon to contend that it would be Bhubaneswar, kindly comes to page 70. Paragraph 61 was placed. Page 70, paragraph 61. It will thus be seen that whenever there is an express designation of venue, kindly pauses here for a moment. The next part are the exceptions. No and no designation of any other alternative place as the seat, combined with a national body of rules governing the arbitration, and then 3, no other significant contrary indicia. The inexorable conclusion is that the stated venue is actually the juridical seat.
Yes.
Here, there are 3 differentiating characters. A, there is a designation of an alternate place of arbitration, Kolkata. 2, combined with a supranational body of rules governing the arbitration, we have that. It's ICC rules. 3, no other significant contrary indicia. We have the contrary indicia. So this judgment really is helping me to say that this is not the seat. But I need not trouble your lordship with the other point, the other judgment, serial number 2, on the same issue. Now, my lord, on the issue of the place of arbitration, my learned friend had placed serial number 3, page 111. My lord, this was but this judgment can at the highest have a persuasive value. It's of a different, my lord, court. But even apart from that, kindly see page 123, paragraph 46, which my learned friend had placed. What kindly sees, this judgment only proceeds on the basis, may I place it? In this case, the initial arbitral proceedings were held at Kolkata. There is no dispute that no part of cause of action has arisen in Mumbai. There cannot be 2 or more seats of arbitration, whereas the venue of arbitration may be more than one and may be fixed by the parties as well as the learned arbitrator, considering the convenience of the learned arbitrator and the parties. The venue decided by the learned arbitrator to suit his convenience or the convenience of the parties for the purpose of hearing of the arbitration proceedings cannot confer supervisory jurisdiction of such court within whose territorial jurisdiction such arbitral tribunal were held at the venue decided under section 23 of the Arbitration Act. Under section 23 of the Arbitration Act, in the absence of an agreement between the parties, the arbitral tribunal had to meet at any place for conducting the hearing at the place of convenience in the matter. But this again possibly aids me.
Yes.
Because here the arbitral tribunal, for the convenience of the parties, had proposed alternate sittings in Calcutta and Delhi. But that really will not give either this court the jurisdiction or the Delhi court. All has to be seen is whether there is any designated place or seat of arbitration, which the rules clearly specify.
Yes.
Now, my lord, the next judgment, page 126, on this same issue of place of arbitration. And paragraph 14 at page 142, 132, if my lord is pleased to take a look at. But just to give your lordship in a nutshell, my lord, the facts, the seat of the arbitration here was Kuala Lumpur. Because of COVID, my lord, parties agreed that the place of arbitration, the venue would be shifted to Amsterdam or London. So, my lord, in those facts, my lord, the court held that, my lord, that could not amount to shifting of the seat outside Kuala Lumpur. Because of the convenience, the sittings may have been held elsewhere. Kindly see paragraph 21.
Yes. Anything else, Mr. Gupta?
No, not on this, not on jurisdiction. My lord, now yes, my lord, one other issue which my learned friend had argued was that amendment application being dismissed cannot be a ground in 34. I have to await for the final adjudication. To that, I had already made my submissions that, my lord, your lordship would see from the nature that there is final adjudication. I had also placed, my lord, the 2 or 3 questions in the cross-examination which were disallowed. So, my lord, this really partakes the character of adjudication of the rights finally. So, my lord, if I don't challenge that, I would be stopped from, my lord, contending to the contrary in the arbitration. So, my lord, I would lose my time, lose my right for all times to come in the arbitration.
That's it.
Yes, my lord.
Yes. How much time will you take?
Within half an hour, I'll try to conclude.
I'll come back in 5 minutes.
Sure.
Good idea. Let my learned friend submit. In case he submits any new judgments, my lord, I shall in my rejoinder.
Thank you.
My junior is there, my lord.
Yes.
Lordship, can I just satisfy the Honorable Court on the issue of territorial jurisdiction? If your Lordship will see page 4, para 4 of their section 34 petition, volume 1, your Lordship. This is their only case as to how this Honorable Court has been vested with territorial jurisdiction in respect of this petition. In fact, para 3 and para 4 both at page 4. Lordship will see para 3. Further, the said agreements also contain that the said arbitration.
This will carry on till.
I'll come back at 2 o'clock.
Lordship may kindly see para 3 at page 4. Further, the said agreements also contain that the said arbitration shall be conducted and the proceedings shall be in Cuttack. Your Lordship may take it as Bhubaneswar. Cuttack, it is a typographical error. The contract says Bhubaneswar. Typographical error, it is Bhubaneswar. Now, in next para, they say how I have waived this in para 4. The present arbitral reference is being held at Indian Chamber of Commerce and at Delhi alternatively. The fact that the meeting shall be held alternatively in Kolkata and Delhi was by consent of the parties and is recorded in the minutes of meeting dated 11/12/23 and 13 January 24. A copy whereof is annexed hereto and marked as so and so. It was also recorded in such meeting that the venue of the arbitration would be Kolkata and Delhi alternatively at the choice of the parties. It is by virtue of such that the exclusive jurisdiction clause and or implementation thereof was mutually waived by the parties. It is their own understanding that the seat was at Bhubaneswar, but because I agreed for alternate hearings in Delhi and Calcutta, I waived it. There is no pleading in entire section 34 petition that by virtue of these ICC rules, the seat of Calcutta has been incorporated. There is no pleading. This is their only case. This also shows their understanding. Yes, the seat was Bhubaneswar, but I have waived it. This is the entire contention, Your Lordship. Now, Your Lordship may see para clause 14 at page 32 of the paper book very categorically says that the, if Your Lordship may for a moment kindly have page 32, running page 32, clause 14, which is the arbitration clause. Your Lordship has it? Your Lordship may just see the last line. I will not bother Your Lordship with the entire clause. Last line. The venue of arbitration shall be Bhubaneswar. Your Lordship has it?
Yes.
There is no contrary indication of any other place in the contract as far as the contract is concerned, Your Lordship. I'll read the entire.
Clause 14. The venue of arbitration shall be.
Shall be Bhubaneswar. The contract doesn't say any other place.
Yes.
Now, Your Lordship, my submission based on this is that as per the judgment of BGS Soma, which is the first judgment in my compilation, Your Lordship, it says if the venue is mentioned and there is no specific mention of any other place as the seat, that specific venue has to be treated as
It also records that it will be Indian Chamber of Commerce.
Yes, Indian Chamber of Commerce. I will satisfy Your Lordship on that also. Yes.
Quite clear.
Yes, it reads so. Now, Your Lordship, that as per the judgment of BGS SGS Soma, this venue has to be treated as seat. Now, Your Lordship, my learned friend has sought to argue, although not pleaded, although when they would have prepared the case, if they would have thought about this point, they have relied on Rule 30. And by reading Rule 30, they say because the institute that is concerned is Indian Chamber of Commerce, as per Rule 30, the seat of arbitration has been incorporated as Kolkata. Rule 30 at page 17, Your Lordship. Last rule, Rule 30. The place or venue of arbitration shall be Kolkata, India. However, the venue having regard to the convenience of arbitrators and parties may determine the venue and hold the proceeding at such place or places in India. In case the venue is outside Kolkata, the parties have to bear all additional costs. Now, Your Lordship, my submission to the Honorable Court is this clause Rule 30 is exactly what section 20 subsection 3 of the Arbitration and Conciliation Act provides for. It talks about the venue. I can give my copy.
Order sheet galat.
One copy is already given.
Yes, yes.
Rule 30 at page 17, Your Lordship. Page number appears at the bottom. By reading this rule, they say that Calcutta has been incorporated as the seat because the arbitration is continuing as per the Indian Chamber of Commerce rules. This may not be correct, Your Lordship, because Rule 30 is exactly what Section 20, subsection 3 of the Arbitration Act provides. Now, Your Lordship, if Rule 30 always incorporates the seat to be Calcutta as per these rules, then in that case, Your Lordship may kindly for a moment have Rule 2, Sub-Rule 10, which Your Lordship will find at page 6 of these very same rules.
Page?
Page 6. Page 6. Roman 10, Your Lordship. The definition of court. Your Lordship has it. Court means a civil court having jurisdiction to decide the question forming the subject matter of the reference if the same had been the subject of a suit. Now, Your Lordship, this 210, if their interpretation is given effect to, then 210 will always say that the courts at Calcutta will have jurisdiction. 210 is exactly what section 2 subsection 3 2E.
ये दूसरा है ना, ये तो OCL है.
Then the clause 10 will always say that the court means the courts at Calcutta if their interpretation of Rule 30 is given effect to. Clause 10 is exactly what section 2E of the Act says, and Rule 30 is exactly what section 20 subsection 3 says. It is completely in consonance with what the Act says. Now, Your Lordship, on their contention of that, I have waived by agreeing for alternate hearings in Calcutta and Delhi.
Yes.
This is contrary to what the record says. For a moment, Your Lordship, may have running page 54 of the section 34 petition.
Yes. Running page?
Running page 54, Your Lordship. This is Annexure C, colleague.
Yes.
Your Lordship may have 54. This is my notice invoking arbitration to the institute. At page 53, Your Lordship may see the subject, notice of request for arbitration under sale and purchase contracts. This is my notice invoking arbitration. Now on 54, Your Lordship may see the second paragraph. In the arbitration clause, Your Lordship has it. In the arbitration clause of the two sale and purchase contracts, as stated here in above, kindly note that the venue of arbitration is not Kolkata. Same is Bhubaneswar. Accordingly, it is requested that in terms of Rule 9 of the rules of IC's group, panel of arbitrators maintained by ICA, New Delhi may be adopted by the council. So even during invoking arbitration, I am not waived it. I am asserting.
You are challenging in terms of the jurisdiction part, right?
On the issue of jurisdiction to show that I am not waived. While invoking arbitration also I said so. It is not Kolkata, it is Bhubaneswar. Number one. Number two, Your Lordship, at page 32, Your Lordship will see there is a specific clause, clause 18, which says for any amendment to the terms of the contract, there has to be a written and signed agreement. Clause 18 at running page 32.
Yes.
The Videocon judgment in my
Any amendment to this agreement shall be in the form of an addendum to be signed.
Yes, yes. There is none. There is none. In this context, Your Lordship, I am relying on this judgment of Videocon Industries, which is the fourth judgment in my compilation.
Yes.
For a moment, Your Lordship may have page 132 of the compilation, which is a relevant portion.
Yes.
In fact, starting from 132, Your Lordship, para 14. Shri Nariman then argued that after having expressly consented to the shifting of the seat of arbitration from Kuala Lumpur to Amsterdam in the first instance and effectively taken part in the proceedings held at London till 31st March 2005, respondent number 1 is stopped from claiming that the seat of arbitration continues to be at Kuala Lumpur. The learned senior counsel submitted that the learned single judge was not justified in rejecting the objection to the maintainability of the petition filed by R1. in the Delhi High Court merely because the appellant had earlier filed OMP number so and so before the High Court. He submitted that the doctrine of waiver and acquiescence cannot be pressed into service for deciding the issue relating to the jurisdiction of Delhi High Court to entertain the petition filed under Section 9 of the Act. Shri Nariman further submitted that if the respondent number 1 felt aggrieved against the partial award, it could have filed petition under Section 67 and 68 of the English Arbitration Act 1996. Next paragraph, Sri Gopal Subramaniam, learned Solicitor General, submitted that as per the arbitration agreement, which is binding on all the parties to the contract, a conscious decision was taken by them that Kuala Lumpur will be the seat of any intended arbitration, Indian law as the law of contract and English law as the law of arbitration. And mere fact that the arbitration was held outside Kuala Lumpur due to the outbreak of epidemic SARS, the venue of arbitration cannot be said to have been changed from Kuala Lumpur to London. The learned Solicitor General emphasized that once Kuala Lumpur was decided as the venue of arbitration by written agreement, the same could not have been changed except by amending the written agreement as provided in Article 35.2 of the PSC. Then the court considers this issue at para 20. It says, because there has been no amendment as per Article 35.2 of the PSC, there has been no amendment and the seat will continue to be Kuala Lumpur. This is an exact clause in my agreement also. There is no amendment.
Clause 18.
Yes, clause 18 of my agreement. Now, Your Lordship, just to satisfy this honorable court that I can have n number of venues that will not have any effect on changing the seat, I am relying on a judgment of the Honorable Supreme Court by the name of BBR India. Your Lordship, I'll just read two paragraphs.
I've seen it.
Yes.
Which serial number? Oh, no. I think this issue is settled now.
Yes, yes.
Yes.
Lordship may at page 13, Your Lordship may have para 19.
Yes.
Relying upon the constitutional bench decided in Balco in BGS SGS Soma, this is the same judgment, the first judgment in the compilation, Your Lordship. It has been held that subsection 3 of section 20 refers to venue, whereas the place mentioned in subsection 1 and 2 refers to the jurisdictional seat. To explain the difference in Balco, a case relating to international arbitration, reference was made to several judgments, albeit in judgment of Shashua versus Sharma, was extensively quoted to observe that an agreement was the seat of arbitration, draws in the law of the country as the curial law and is analogous to an exclusive jurisdiction clause. The parties that have agreed to the seat must challenge an interim or final award only in the courts of place designated as the seat of arbitration. In other words, the choice of the seat of arbitration must be the choice of forum court for remedies seeking to attack the award. The aforesaid principles relating to international arbitration have been applied to domestic arbitrations also.
So, but if you rely on this, then you should have gone to Bhubaneswar.
I'm defending it here. I am, of course, if something.
It says, if you read the parties that have agreed to the seat must challenge an interim or final award only in the court of the place designated as the seat of arbitration.
They have challenged it, Your Lordship. I'm defending it here.
According to you, the seat of arbitration is
Bhubaneswar.
Yes.
Because BGS Soma is very clear. If the venue is only venues mentioned, that has to be treated as seat.
correct.
So my submission is that the seat is in Bhubaneswar, not here.
Correct. That's what I'm saying.
Yes.
I'm also saying the same thing.
I'm so sorry, Your Lordship.
I'm saying the same thing.
I am defending the award. They have challenged it
Then
here.
it
And
says, in
I'm,
other words, the choice of the seat of arbitration must be choice of a court, forum or court, remedy seeking to attack the award.
yes. Now, Your Lordship, for a moment, in this very same judgment, Your Lordship may have para 23 at page 15.
23.
Para 23 at page 15. Your Lordship has it?
Yes.
I'm reading from the fourth line from the top. In the context of domestic arbitrations, Your Lordship has it?
Yes.
In the context of domestic arbitration, it must be held that once the seat of arbitration has been fixed, then the courts at the said location alone will have exclusive jurisdiction to exercise the supervisory powers over the arbitration. The courts at other location would not have jurisdiction, including the courts where cause of action has arisen. As observed above, held in BGS, SGS, Soma and Indus Mobile, the moment the parties by agreement designate the seat, it becomes akin to an exclusive jurisdiction clause. It would then vest the courts at the seat with exclusive jurisdiction to regulate arbitration proceedings arising out of the agreement between the parties. Now, your lordship, for a moment, have para 30 at page 18 of this judgment. Para 30 at page 18, your lordship.
Yes.
Para 30. There are good reasons why we feel that subsequent hearings or proceedings at a different location other than the place fixed by the arbitrator as the seat should not be regarded and treated as a change or relocation of jurisdictional seat. This would, in our opinion, lead to uncertainty and confusion relating in avoidable, esoteric, and hermetic litigation as to the jurisdictional seat of arbitration. The seat once fixed by the arbitral tribunal under section 20, subsection 2 should remain static and fixed, whereas the venue of arbitration can change and move from the seat to a new location. Venue is not constant and the stationary and can move change in terms of subsection 3 to section 20 of the Act. Change of venue does not result in change or relocation of the seat of the arbitration. It is highly desirable in commercial matters, in fact, in all cases, that there should be certainty as to the court that should exercise jurisdiction. We do not think the law of arbitration visualizes repeated or constant shifting of the seat of arbitration. In fact, subsection 3 of section 20 specifically states and draws a distinction between the venue of arbitration and the seat of arbitration by stating that for convenience and other reasons, the arbitration proceedings may be held at a place different than the seat of arbitration, which location is referred to as the venue of arbitration. Your lordship, on the next page may have for a moment have para 32.
Yes.
Your lordship, I'm reading from the fourth line. Exercise of supervisory jurisdiction. Your lordship has it?
Yes.
Exercise of supervisory jurisdiction by the courts where the arbitration proceedings are being conducted is a relevant consideration but not a conclusive and determinative factor when the venue is not the seat. The seat determines the jurisdiction of the courts. There would be situations where the venue of arbitration in terms of subsection 3 of section 20 would be different from the jurisdictional seat, and it is equally possible majority or most of the hearings may have taken place at a venue which is different from the seat of arbitration. Further, on balance, we find that the aspect of certainty as to court's jurisdiction must be given and accorded priority over the contention that the supervisory courts located at the place akin to the venue where the arbitration proceedings were conducted or substantially conducted should be preferred. Now, your lordship have para 33.
Yes.
9th line from top. There could be cases. There could be cases.
Yes.
There could be cases where the arbitration proceedings are held at different locations, but the seat of arbitration as agreed by the parties or as determined by the arbitrator may be different. And at that place, the seat, only a few hearings or initial hearings may have been held. This would not matter and would not result in shifting of the jurisdictional seat. Arbitrators can fix the place of residence, place of work, or in case of recusal, arbitration proceedings may be held at two different places as in the present case. For clarity and certainty, which is required when the question of territorial jurisdiction arises, we would hold that the place of the venue fixed for arbitration proceedings when subsection 2 of section 20 applies will be the jurisdictional seat, and the courts having jurisdiction over the jurisdictional seat would have exclusive jurisdiction. This principle would have exception that would apply when by mutual consent the parties agree that the jurisdictional seat should be changed. There is no mutual consent in my humble submission to this honorable court. My consent was only in accordance with section 20 subsection 3. And such consent must be expressed and clearly understood and agreed by the parties. So, hearings in Delhi and Calcutta cannot vest either the Honorable Delhi High Court or this Honorable Court with jurisdictional with jurisdiction over the present petition. It can be only the principal commercial court at Bhubaneswar, no else court. And the ICC arbitration rules cannot incorporate Calcutta, because then in that case the court will always be defined as the courts in Calcutta under those rules. It does not say so. That definition is exactly in consonance with section 2 subsection E, 210 of those rules. That is verbatim same, word by word same, as defined in section 2E of the Act. Nothing else.
So 30 has to be read with 210.
Yes, you can't roll 30 in isolation. Now, Your Lordship, they had raised an argument that the stamping of the impugned order has been done on a stamp paper which is of West Bengal, and possibly that could determine the seat to be in Calcutta and vest this honorable court with the jurisdiction. On that issue, Your Lordship, for a moment, if Your Lordship will have a judgment of the Honorable Bombay High Court, they had twofold arguments, Your Lordship, that the impugned order was passed in Calcutta and it is stamped on a stamp paper which of the state of West Bengal. In that context, Your Lordship may have para 7 at page 3 of this judgment. Para 7, Your Lordship has it. By the present application, the respondent contends that the petition under section 34 of the Act for challenging the impugned arbitral award could have been filed only before the court at Thane. The respondent contends that the agreement contract executed between the parties specifically stipulates that all disputes shall be deemed to have arisen within the jurisdiction of Navi Mumbai, which is covered under the jurisdiction of the said court at Thane. It is further contended that except 2 hearings, all the 22 hearings in the arbitral proceedings had taken place at Navi Mumbai. It is further contended that the building of the petitioner society in respect of which contract was awarded to the respondent is also situated in Navi Mumbai. The respondent further contended that since the application filed under section 9 of the Act was filed before the said court at Thane. In this matter, Your Lordship, section 9, no section 9 was filed, so this may not be relevant, this portion of this para. As per section 42 of the Act, the petition filed under section 34 thereof ought to have been filed before the court at Thane. On the basis, the respondent has claimed in the present application that the present petition deserves to be dismissed. In reply, para 8, Your Lordship, in reply, the petitioner contends that the award signed by the learned arbitrator records the date of its pronouncement and the place as Mumbai. It is contended that therefore the place of arbitral proceedings and award is Mumbai, due to which this court has jurisdiction to entertain the petition filed under section 34 of the said Act. Now, Your Lordship, the Bombay High Court considers this contention at para 27 at page 14, Your Lordship. Your Lordship has para 27.
Yes.
Merely because the award records that the same was published at Mumbai cannot be the basis to hold that the place of arbitration in the facts of the present case was Mumbai. The emphasis placed on behalf of the petitioner on the fact that the award was signed and published at Mumbai cannot be of much assistance for holding that the place of arbitration was indeed Mumbai. This is because mere signing of the award at a place cannot be the determinative factor for ascertaining the place of arbitration. For instance, if there is no agreement between the parties as regards the place of arbitration, the arbitrator has not determined the place of arbitration and the arbitral proceedings are conducted at place A, while the learned arbitrator for some reason goes to place B and signs and publishes the award at place B. It cannot be said that the place of arbitration is B. The overall circumstances would have been taken into consideration to reach a conclusion on the aspect of the matter. So the mere fact that the learned arbitrator in the present case, which Your Lordship is seized of, published the award or passed the award at Calcutta cannot vest this honorable court with jurisdiction under section 34 of the Act. Is my submission to this honorable court. And I also showed to Your Lordship that at page 54, where even at the time of invoking arbitration, I had said that the place is Bhubaneswar, Kolkata is not the jurisdiction. So where have I waived? And clause 18 has not taken effect. Now, your lordship, just for your consideration, if their interpretation as they have pleaded in para 4 at page 4 of the petition, that because alternate hearings were agreed to be held in Kolkata and Delhi, then this will result to a situation where the Delhi High Court can also claim jurisdiction.
Yes.
There cannot be two courts having jurisdiction over a same arbitration proceeding. Now, your lordship, for a moment, my second, this was my preliminary objection.
Yes.
For your lordship's kind consideration. The second preliminary objection is this, your lordship, that an order rejecting an amendment application can be only challenged after final is award. Now is not the stage. In that aspect, your lordship may kindly see why I'm saying is because they're wanting to paint a picture, because that order reads as this is an interim award, so this is an award and can be challenged. But your lordship will kindly see what is their pleading in the section 34. For a moment, your lordship has page 12 to 16 of their section 34 petition, starting from para 20 onwards. What they are challenging? They are only challenging the rejection of their amendment, nothing else. For a moment, your lordship has page 12 of the section 34 petition, para 20 onwards at the bottom. Your lordship has it. The learned soul arbitrator in the passing of the interim award had done the following. The learned arbitrator has erred in failing to appreciate that while returning a finding that there is no need to allow the amendment sought by the petitioner, inasmuch as the real intent and purport of the interpretation of the clause prejudged an issue in the arbitration without granting an opportunity to the petitioner to lead evidence to the contrary. Para C. The learned sole arbitrator has erred in failing to appreciate that erroneously and without any justification or reasons came to a conclusion that merits of an amendment can be looked into if an attempt is made by the party seeking an amendment to resile from and admission made by him by virtue of his pleading or otherwise. Further, in such finding, erred in failing to appreciate that no attempt to resile from an admission was sought by the petitioner. Para E. The learned sole arbitrator has erred in coming to a finding that there is no necessity for the amendment inasmuch as the penalty clause was plain and simple and that the clause never stipulated penalty to be calculated after deduction of value of typical specs and tolerance without granting an opportunity to the petitioner to lead evidence to the contrary and prevented the petitioner from seeking adjudication upon trial on evidence on such issue. Para 21. The learned sole arbitrator has erred in failing to appreciate that an application for amendment of pleadings ought to be heard prior any other pending application. Now, your lordship, till para 28, the entire thrust is on rejection of the amendment. In this context, your lordship may also kindly see page 5 of the petition, wherein they are specifically saying, I showed 8 paragraphs of the petition, your lordship, wherein their sole thrust is on the rejection of the amendment. And what they have to say on my 31(6) application, that your lordship will find at para 6 at page 5 of the petition. It is also pertinent to mention page 5, para 6, your lordship. It is also pertinent to mention that inasmuch as a part of the claim as made in the statement of claim by the respondent was correct, the petitioner had in its SOD admitted to such amounts, copies of pleadings before the learned sole arbitrator annex and collectory martu letter C. They don't have a problem of me getting the amount. They have a problem with the rejection of the amendment. Now, my submission to the Honorable Court is, I'll just give para number, that para and page number, your lordship, that an order rejecting an amendment can be only challenged once the final award is pronounced, not prior thereto. In this context, I am relying on para 19 and 20 and at page 198 of my judgment compilation, your lordship. In fact, para 6 at page 193, for a moment, your lordship may have it. Continue cooperation.
Yeah. Para 6.
Para 6 at page 193, your lordship. Your lordship has it?
I consider that
Yes, I consider that dismissing of an application for amendment of the written statement whereby the petitioner was not allowed to include the counterclaim of at a belated stage cannot be termed as an interim award so as to allow challenging such order under section 34. The petitioner would be at liberty to assail the final award and can take all the ground of challenge as available under law as and when final award is passed by the learned arbitral tribunal. The petitioner cannot be allowed to challenge dismissal of its application for amendment as an interim award. One of the purpose of enactment of Arbitration and Conciliation Act 1996 was to minimize the intervention of the courts during arbitral proceedings, and that is why Section 5 of the Act prohibits the courts from interfering in the arbitration process. The judicial intervention during arbitral proceedings is not permissible unless it is specifically provided by Part 1 of the Act. The effect of non-obstantive clause in Section 5 is that the provisions of Part 1 of the Act will prevail over any other law for the time being in force in India. Now, Your Lordship, it is his contention that, see, my amendment application, Mr. Gupta spent a considerable amount of time that his amendment application had to be decided first before the learned arbitrator taking up any other application, including my 31(6) application. In that context, Your Lordship, the council has not pointed out to this honorable court a very relevant fact, which is recorded at internal page 8 of the award. Your Lordship, the award starts after running page 669. Internal page 8, Your Lordship may have it.
Yes.
It is pertinent to note that the application for amendment of SOD has been filed by the respondent. The same is taken on record and by consent of the parties is considered simultaneously with the application under section 31(6) of the Act. They had given consent that the learned tribunal can decide both the applications simultaneously. Now here before this honorable court, it is sought to be argued that this had to be decided first. Now, in that context, Your Lordship, if I may point out, I have filed a written submission which they filed before the learned tribunal. Your Lordship, for a moment, have my reply at page 51 of my reply, Your Lordship. I have placed on record their written arguments which they filed before the learned tribunal. Notes on argument on behalf of the respondent on the amendment application and the application under section 31(6). They had even filed a consolidated and a conjoint written submission both on the amendment application and 31(6) application. So today you cannot argue that despite my contention, the learned arbitrator proceeded to decide the amendment, proceeded to decide the 31(6) application prior to the amendment application. This was not pointed out to this honorable court. Now, Your Lordship, I can also point out a very pertinent fact on the issue of grant of interest. Mr. Gupta had spent a considerable time that the learned arbitrator could not have granted me interest. Twofold arguments on this, Your Lordship. First, he refers to page 301, Annexure G, to say that I had categorically asked them to come forward and give their consent so that the amount mentioned therein can be refunded. Since I did not come forward, so interest could not have been granted.
After that date.
After that period. Lordship, what has not been pointed out to this honorable court, that after this email, I have issued a legal notice to them, asking them to pay me at least the admitted amount. They say not a single penny is payable to you and we will not pay you a single amount. So today, this offer of payment, which they say is a valid tender, is a farcical argument. Because after this argument, I made my demand by way of a legal notice. I will give the page number to this honorable court, Your Lordship. Okay. Your Lordship may kindly note the page number. Your Lordship may have page 189 of the paper book, Your Lordship, which is my legal notice asking for payment. The legal notice starts at page 189, sorry, 189. Your Lordship has it?
Yes.
This legal notice, Your Lordship may kindly don't note the date, 11th March 2022, which is subsequent to that tender, the so-called tender of offer of payment. Now at page 195, Your Lordship may kindly have para 8. Your Lordship has it?
Yes.
Para 8. Your Lordship may kindly have 11th line from the top. I'm so sorry. It bears mention that monies.
Yes.
11th. It bears mention that the money is owed. Your Lordship has it?
Yes. Money owed by
Messrs. SM Niryat. Your Lordship, this petitioner was earlier known as SM Niryat. They have undergone. Now they are known as OCL Iron Industry. It bears mention that the money is owed by SM Niryat to my client with respect to PDN coking coal supplied under RR number so and so has not been disputed by Messrs. SM Niryat, and thus without prejudice to my client rights to seek recovery of monies under PDN coking coal supplied under the rest of the RRs, SM Niryat is called upon to forthwith deposit this amount. Now Your Lordship may kindly see what the response is to this legal notice. Your Lordship will find that their reply is at page 206, Your Lordship. The reply starts at page 206, and Your Lordship at 210, Your Lordship may have last paragraph, paragraph 10.
Yes.
In light of the above, we urge you to withdraw the said notice and advise your client JCL to refrain from raising frivolous claims and or demands against our client. So where was the tender? Why will I not be paid interest? Now, Your Lordship may also note one very pertinent fact. In their entire section 34 petition, there is not a single grant challenging the grant of interest. Your Lordship will find the grounds of 34 start at page number, they start from page number 18 and go up till page number 23 of the section 34 petition. There is not a single ground challenging the grant of interest to me. Today, can they argue beyond their pleadings? And 31(7) says, wherever the money is found to be due and payable, the interest can be granted by the honorable tribe, by the learned tribunal. Now, Your Lordship, one more very valid point. For a moment, Your Lordship may have Annexure G at page 301, running page 301. Page 301, Annexure G. This is the same email which is hotly contested between the parties, Your Lordship. Annexure G, Your Lordship has it. Lordship will, has noted that there are two refundable amounts at the bottom. Refundable amount of 34,04,409 and another 40,15,491. They add up to 74,19,000. Now, Your Lordship, basis this email of 9 December 2021, the date appears at the top. 9 December 2021. My learned friend has argued, by way of this email, I had made a valid tender of offer of payment. I did not come forward, so no interest is payable. Your Lordship may see the last line of this email. Kindly confirm the above, enabling us to process the refund. Heavy reliance was placed on that this is a valid tender offer. Your Lordship has it. Now, Your Lordship may kindly see how the petitioner is seeking to approbate and reprobate. At the same time, the petitioner is saying that these amounts I wanted to amend, which is 34 lakh and 40 lakhs. This is not the amount that I had acceded to in my SOD. And simultaneously, he is relying on this very same email to say that by way of this email, I had made a valid tender, so no interest will be payable. Either you rely on this or you don't rely on this. You cannot rely on this where it suits you and not rely on this where it does not suit you. For amendment, you are saying this email is not correct. But for interest, you are saying I had made a valid tender. Now, your lordship, one more argument, just to satisfy your lordship's conscience as to why the amendment has been rightly rejected. For a moment, I will beseech your lordship to have page number 301, the very same email, and page 30 of the paper book side by side. For a moment.
301 and page?
Page 30 and page 301, your lordship.
Page 30 of the
Of the paper book, which is clause 4 of the contract.
Yes. Yes.
Page 30. Lordship may kindly, at page 30, your lordship will kindly see specifications. Your lordship, the second entry is ash percentage.
Yes.
Now the entire dispute before your lordship is about the ash percentage. There is no other dispute which the learned arbitrator has dealt with. Now your lordship may see there is a column of typical specs as 10. Now the tolerance is 0.5. Rejection is anything above the ash percentage above 11.5 is liable to be rejected by me. I was the buyer, they were the supplier. Now your lordship may see the penalty clause, which is the last column. If results exceed, your lordship has it.
Yes.
If results exceed tolerance, meaning thereby if results exceed 10 plus 0.5, 10.5, because it says tolerance. So if results exceed tolerance, 10.5, INR 60 per metric ton for each % above typical specs. So the penalty of 60 rupees per metric ton is to be above typical specs, which is 10. So if you exceed 10.5, I will impose penalty as if you are over 10. The language is very clear, your lordship. Now in this context, your lordship may kindly see page 301 also, what they have calculated. In the second tabular chart, your lordship, which is as contract says 10.
Ash report 10.6.
As report is 10.613. Now your lordship will see penalty is 36.78. Yes. Now your lordship, this 36.78 can be only reached at, which is 10.613 minus 10. What they are today contending is that it should be 10.613 minus 10.5. It cannot be so. It has to be 10.613 minus 10 into 60, which is the rate of penalty under clause 4. And that's how you have reached at a figure of 36.78. Lordship, for a moment, I will again try to explain myself. 10 point as contract is 10, not disputed by any of the parties. It cannot be disputed because it is written in the contract. As contract is 10. As report is 10.613, they are not disputing it. I am not disputing it. So it is 10.613 minus 10 into 60, which is the rate of penalty under clause 4. That's how you reach at 36.78, which is the penalty. It is your own calculation. Today what you are saying is, no, it has been 10.613 minus 10.5, including the tolerance. The language is very clear. Anything above typical specs, I will impose penalty on you. So in that context, the learned arbitrator has said, the language is very clear. How can I go beyond clause 4?
Anything else?
And one more thing, your lordship, which they have not controverted in their entire arguments. Annexure G, they first sought reliance upon in their initial statement of defense. They moved an amendment application. Mr. Gupta has also shown you the 3 paragraphs that were sought to be amended. Even in the amended SOT, Annexure G has been relied upon. I'll just give the page number, your lordship, for your convenience. Your lordship may have.
That's not an issue.
Not an issue.
We have relied upon Annexure G in our proposed amended SOT, which was rejected.
Para KK at page 390.
I must, that is, we have relied upon that.
Not controverted.
Saying that.
So even if their amendment application would be allowed, I would be entitled to the entire award.
Yes.
That document still relied upon in the proposed amended statement of defense. Just to reduce the burdens.
Yes.
But Mr. Gupta's on legs, not me. He come back
We'll
for
finish it.
He's
Hey,
currently on legs, not.
The learned friend has been
do-
involved all
I have been involved, not, but he
all
would.
along he has been involved.
I
Say
am
anything.
not.
Let's not stretch it.
I appreciate not he's on legs, not. I just even text him right now that Mr. Sunny is concluding. His
So
clerk
after
just
lunch, 5 minutes.
great.
No, not
I am not seeking an adjournment on that ground, but may I just
after lunch, 5 minutes.
Good. Lord, will just give me more than 5 minutes.
More than 5 minutes, but we'll finish it up.
Yes.
Would your lordship also want a written submission? We can.
Yes, obviously, but then let me hear.
Yeah, of course.
Conclude the hearing.
Yes.
Written submissions will follow within a week. Written submission along with all the relevant judgments
Great. Yes.
to rely upon.
Page
That
reference
will come within a week
We'll do that. Great.
after lunch.
Yes.
Hmm. Supplementary first, just one second.
Sure.
CCOM 273 of 2025, Cholamandalam Investment versus Kartik Bhattacharya and another.
My lord, I am appearing on behalf of the judgment dated number 1.
My lord, appearing for judgment holder, award holder.
Today he surrendered before my lord.
कल आपके फादर को बुलाया था
আর বাবাকে কালকে ডেকেছিলেন বলছে
कि पेमेंट करो आप क्यों फादर को तंग कर रहे हो सबको तंग कर रहे हो
বাবাকে কেন বাবা এই বয়সে ইয়ে করছেন লজ্জা করছেন আপনি পেমেন্টটা করুন
আমি ছিলাম না বাড়িতে টিকিট বিক্রি করি তো লটারি টিকিট তো বাড়িতে ছিলাম না
আপনার বাবাকে আনতে হচ্ছে কোর্টে পয়সাটা দিন ঠিক ডক্টর বলছেন বয়স্ক বাবাকে কোর্টে আনতে
আস্তে আস্তে দিতে হবে
আস্তে আস্তে নিয়ম দিয়ে ওঠ
কি নাম আপনার
কার্তিক ভট্টাচার্য
কার্তিক ভট্টাচার্য দেখো না কার্তিক ভট্টাচার্য বাবার নাম
কালীপদ ভট্টাচার্য
কালীপদ ভট্টাচার্য ভট্টাচার্য আপনার বয়স 42 ইয়ার্স বাড়ির ঠিকানা
কিশোরপুর
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 পোস্ট কিশোরপুর
থানা করিমপুর
পিএস
করিমপুর
করিমপুর
করিমপুর করিমপুর
করিমপুর করিমপুর হ্যাঁ করিমপুর
জেলা নদিয়া
ডিস্ট্রিক্ট নদিয়া কি করেন আপনি
আমি লটারি ব্যবসা করি
পিন কত
741165
741155 আপনাকে যেদিন জজ সাহেব আসতে বলবেন সেদিনকে আসবেন ঠিক আছে
ঠিক আছে
আপনার কাছে একটা ফর্ম আছে ওটাতে অ্যাফিডেভিট করবেন হলফনামা জমা দেবেন আপনার কি সম্পত্তি আছে সেটা যা আছে সেটা দিতে জমা দেবেন এগুলো যদি না করেন তো আপনার ডিউটির ব্যবস্থা নেই। ঠিক আছে
This court-wide order dated 1st December 2025 had issued the warrant of arrest against award dated number गलत लिखा हुआ
जी
बस कर देना award dated number 2 award dated number 1 Kartika Bhattacharya has surrendered before this court. Full stop. Oath has been administered to him.
My lord, may I make a
He-
submission?
Yes.
My lord, considering the age of judgment data number 2,
Yes.
let there be.
You file your affidavit. He has already appeared. Judgment dated number 2 yesterday was here.
Yes, my lord.
Today
But
it's him.
considering the age of the judgment data number 2,
What?
let there be or
Let there be
direction
what?
direction upon both the judgment debtors to file affidavit of asset.
Yesterday only we have given this direction. Yesterday's father was here. Today he has come.
Considering his age, we are praying that let the direction upon on judgment debtor 1 to file affidavit of asset on both the judgment debtors. Or else, my lord,
He has to file separate affidavit of asset. How can he?
publishment.
What? क्या लिखा है?
Both has been administered.
Oath has been administered. Award dated number 1 undertakes to file affidavit of asset within a period of 2 weeks. He further undertakes to abide by the directions, any directions passed by this court, and shall make himself available to the court for examination as and when required. List after 15 January. Warrant of arrest is discharged.
This is a confirm.
Mr. Sir, which matter are you appearing?
There's an execution matter,
Number?
31. No?
Item 31.
It's item 31. It was fixed for today, but
I don't
believe, my
think
lord,
so. I can.
yes, I can quite appreciate it. But I was making a very humble request, my lord. But my instructing junior comes from Delhi. So if your lordship may fix it on any Monday or Friday, subject to the convenience of
Who is there on the other side?
Mr. Banerjee, is it?
Mr.
Mr.
Banerjee.
Ratnakar Banerjee.
My lord, I'm very embarrassed to say this mentioning is actually without any notice.
No,
So
the
I do
court
not have any
court invited.
Absolutely. I was requesting Mr. City for a notice. Now, the thing is that, my lord, we had mentioned this matter on the 7th of November, my lord. At our instance, the matter was listed on the 12th of November, my lord, and thereafter it has been listed on the 2nd of December, my lord. All that I'm requesting is that, my lord, Mr. Banerjee is on legs. Let this be mentioned tomorrow morning, my lord. Whatever the learned AG is saying, sir, my lord, we can just have Mr. Banerjee and sir here and we can just fix the date.
But I am only asking that on any Monday or Friday, whichever day suits Mr. Banerjee.
Let it
Of
run
course,
on
we are
the
subject
list,
to the
my lord.
convenience of business of the court permitting.
Let it run on the list, my lord, because either
it
way,
run
under
on the
new
list.
chamber,
We'll-
it's
I've
as
got your,
listed as item 1, my lord.
We'll
Very
fix it accordingly.
Very good.
Very grateful, my lord.
Let it run on the list.
Very good.
Yes,
I'll
so
be very brief in my reply. I've noted down
all right.
point wise. I'll just give point wise reply. First issue is 2 Roman 10.
Yes.
The definition of court. Court means a civil court having jurisdiction to decide the questions forming the subject matter of the reference if the same had been the subject matter of a suit. Somewhat similar language with the 2(1)E court, had it been the subject matter of the suit. Here, why does not it mention this? That depends on whether, on what happens. That is why this can't really specify which court it would be. Depends on the pecuniary, it depends on the subject matter, where it is, where the has the parties jointly agreed to change of the seat of the arbitration. Nothing. These are the variable factors. That is why, it says wherever the court is, and otherwise also we have satisfied your lordship that this court otherwise also has the jurisdiction. Leaving everything aside, this court otherwise has the jurisdiction because part of cause of action arose here. So that is one dealing with this. Now, I believe we had relied upon Rule 9. Kindly see Rule 9 once. That is page 8.
No, he didn't say anything about Rule 9. No?
I did not.
The only thing he said is that
in the section 21 notice. I'll just indicate. He has not relied
section
upon.
21 notice.
Kindly see, to answer that, may I just... I'm sorry, I framed it incorrectly.
Yes.
A panel of arbitrators shall be appointed by the committee from amongst the persons who are qualified and willing to serve as arbitrators generally or in specific fields and who are from time to time recommended by the Secretary General of the Chamber. Kindly read the next sentence. In case the parties choose venue of arbitration other than Kolkata. In case, may I emphasize on this? In case the parties choose venue of arbitration other than Kolkata, the panel of arbitrators maintained by the Indian Council of Arbitration, ICA, New Delhi, will be adopted by the council. This was never done.
In fact, in my page 54, I say that
This was never done. Section 21 notice was a request. This was never done, is my answer. They could have challenged that. They could have said that I am not agreeing to that. But I would draw analogy of Section 4 of the Arbitration Act, waiver. Principles would somewhat apply here. So, if knowingly they have seen that this provision is not being followed, they could have raised this issue. They have not. Knowing well that this was never changed to any other place. So, this really is going against them. Now, the other point which they have said that we did not mention of Rule 30 in the application. But the point of jurisdiction came in course of argument. So, and this is a point of law. It says that the rules would be covered. I've shown the rules. Now on the jurisdiction issue, they had relied upon 2023. Sit down. Take some time. 2023 1 SCC 693. Lord, we'll kindly have a look at page 7 of the judgment, which they had placed on. Today they had handed up. There's a small compilation of one judgment. Yes. Lord, kindly sees the arbitration clause at page 7. There is no seat, no venue, no place, nothing mentioned. Only a simplicity arbitration clause, nothing else mentioned. Here what happened, the first arbitrator held sittings in Panchkula. He said, I will not be able to carry on. Subsequent arbitrator held sitting elsewhere. There was a prior 34 there in one court, a subsequent section 9 in the other court. The courts in these facts held that since the parties have originally decided on Panchkula, courts for over that area would have the jurisdiction. So a subsequent section 34 may have, prior section 34 may have been filed elsewhere, but that will not give for section 42 jurisdiction because the original sitting was held there. So not here also. This judgment is completely inapplicable. There is no place of arbitration designated here. Nothing is there. And in any event, the jurisdiction is foisted in this judgment on a place where arbitration was held. In our case, nothing was held in Bhubaneswar ever. Yes. So that clause was always given a go by. Now, kindly seize in this judgment one paragraph. Well, it's not relevant. Clause in it. I need not. Lordship need not be troubled. But here there was no clause for any place of arbitration. Now the next issue, the next point which they had submitted is that the lawyer that they had relied upon the reply to the demand notice on the point of valid tender. Yes. But they had indicated the reply to the lawyer's notice to their demand letter to contend that, see, there is a denial of my entitlement. So why would the interest stop to run? This is their argument. To that, my lord, my simple answer is that when we offered to pay you that money, you did not come forward. Then if they had demanded the same money later by a lawyer's letter, so then the interest, my lord, they cannot have the benefit of the interest. Then they're claiming the same thing. When we offered, they did not accept. Now they are demanding the same amount. Then if that be so, then they would not have been entitled to interest. This is one side of the story. The other is, but in any event, the issue of interest was not an admitted position. There was no admission as to interest. So, my lord, the
That is
award
only to counter your argument, since you were saying that they failed to take any interest, though it was an admitted amount, and we were ready to give it.
We were ready to pay at that point of time.
From that day onwards, the interest goes.
From that day
We
on.
were
But otherwise also, I'm saying, even if your lordship is not with me on that,
counter that argument, he was saying
he
that,
said that
I had given a notice, I had asked them to deposit the money. They said no, they can't. So the argument which is advanced by you is not applicable or not fit.
Yes. To that, my reply is, but when we had offered for the reconciliation that please come, they did not. So that amount we had indicated in that letter. Please come. This is the amount for reconciliation so that we can pay. They did not come forward. So, my lord, when they claim the same amount thereafter again, so my lord, then they should not. That is on this issue. But otherwise also, since the contract is silent on interest, But that could have been a final award. There is no admission as to interest in the 31(6) stage. That is my second point. So irrespective of this issue, whether judicial propriety warranted on a summary issue.
Challenging interest.
Yes.
The very levy of interest.
Yes. Now my learned friend had taken a point that we have specifically not indicated the point of interest in the award. But there are general grounds there. I have checked specifically, point has not taken, but there are general grounds which can really cover that point. Now, an argument has been made, and I give this reply with some sense of responsibility. That, my lord, it was my contention in the arbitration that amendment has to be heard first. I had prayed for that. Now the tribunal chose not to grant that to me and directed exchange of affidavits in both. So we had to do the hearing in both as it is falling from the. I cannot quarrel with the learned arbitrator. But just to give an example, Lordship will kindly not take me amiss. On the last 2 days, I had offered to deposit the check. Your Lordship has not permitted that. And that's your Lordship's discretion, my lord. But I am only to submit. And it's your Lordship's discretion whether your Lordship would accept or not accept. But that does not mean that I will quarrel or say anything. But, my lord, that does not mean that I have not made that point. I had indicated it might find favor with the judge, it might not. But the fact that the arbitrator in the award has held that both have been consented to be taken together is my specific pleading in paragraph 19 at page 12 of the application that this is an erroneous recording. That I had submitted that this should be heard first. But since the arbitrator said no, I would. So I had, what else can I do, my lord? We are in the hands of the arbitrator. So, but that does not mean that I have not submitted. But I was there in the arbitration. I had made specific submissions on that. Remember the 2 other points remaining. That signing of the agreement at one place does not confer jurisdiction. So, my lord, this was relied. This point was
relied on a judgment of a Bombay.
Relied upon a Bombay judgment. The Bombay judgment, your Lordship would see, does not have any specific place of arbitration mentioned.
The sittings were in Navi Mumbai.
Sittings were differently held. So the finding of the court is if sittings were held in A and the arbitrator would pass the award in B, that does not give the B court judgment.
That's what
Here sittings were held in Calcutta. Place of jurisdiction as per the rules is Calcutta. The award is in Calcutta. So I really do not know how this judgment would come to the aid. And Mullet kindly sees the.
Was only pointing it out to the extent of.
The stamp paper and the signing. Yes. But this is not the sole factor which I had based my argument on. Had that been the case, absolutely, my learned friend had a point. But my argument is throughout relying on several other. This is one of the points. Kindly only sees two paragraphs of this judgment. Paragraphs 27 and 28. But here, the determinative factor was, in this judgment, for instance, if there is no agreement between the parties as regards place of arbitration, the arbitrator has not determined the place of arbitration and the arbitral proceedings are conducted in place A, while the learned arbitrator for some reason goes to place B and signs and publishes the award at place B, it cannot be said that place of arbitration is place B. This is really 3 factors here. Not at all applicable, and also the overall circumstances which would have to be taken into consideration. Here, kindly sees the overall circumstances.
Yes.
Now, the other thing is that the last submission is that Annexure G is what we rely upon for the valid tender point, yet we are trying to say that the figures were wrong, so wanting to amend the SOT. So this is approbate and reprobate and cannot go hand in hand. This is one of the contentions. Now, Annexure G figures are adding up to 74 lakhs. Even in our amended statement of defense, we are admitting to 72 lakhs. Issue is with regard to balance 2 lakhs. We had indicated them, I am ready to pay, come have let's reconcile our accounts, we will pay. And in our amended statement of defense, we only wanted to give a clarification and explain that why some figures should be there and why some should not be there, really on the contract clause. So, my lord, these two are really not, my lord, going on the same path. It's not a case of approbatory probate. My lord,
What
I
you're
am
saying in that in annexure G,
yes,
the figure which is reflecting is 10.0 and 10.6.
10.613.
So that this is
So which in my statement of defense only, we have mentioned it is 0.113, deducting 0.5. That is annexure A, the schedule. So we have already taken a stand. We have already explained that. But in the paragraph where we have said, see that schedule, the schedule would give a different figure, which is the correct figure according to us. But in the body, the wrong figure had come. That is the only change. In the annexure, we have already mentioned the correct figure which we want to incorporate by way of amendment. But in the SOD which was filed, the figure was mentioned as explained in annexure A, but the figure is not what is there in annexure A, but in annexure G. So this is the erroneous thing which we wanted to clarify. So the nature is really completely different from approbate and reprobate which there are. But will kindly give us a week's time, we shall file our notes.
Irshad. Irshad. Matter heard. Behaving. Parties are directed to file their brief written synopsis not exceeding more than 5 pages, along with all the relevant judgment they wish to rely upon within 1 week. Both matters. Both the matter.
We should be filing it with my lord.
Yes, yes.
I'm so
Lordship,
grateful for
can-
providing us the opportunity of.
Can we give the page reference from the compilation, Lordship, from this compilation which we handed over?
You can
Or we can file afresh, we can file it.
file afresh. That'll be more helpful for
All right,
me.
we will file afresh.
In one place with the note, your lordship can always.
Yes,
refer.
I
With the
can always-
compilation also.
with the compilation.
My lord, could we take back the rules and
Yes,
photocopy that same
Yes, sure.
with the note, my lord? So then it would be.
Yeah, just give me a copy.
Yes,
Make
I
it a
have to.
photocopy, but give
Yes, yes. This is one of my sheet anchors.
Yes,
but I'll have to.
absolutely.
I think I should have given a laminated copy, but I'm so grateful.
Lordship, will the matter be listed or we can just file it with the.
Just file it with the code.
Great, great.
Next.
Number 13 with 14.
13, 14, 15, 16.
বাইরে আছে দাঁড়া নিয়ে আসতে বলো
Yes, yes.
তোমার বিটটা বার করে দিয়ে অ্যাওয়ার্ডটা বার করো তাড়াতাড়ি বলো ডাক জাজমেন্ট গুলো আছে তো সেন্ডিং ফর তোমাদের I'll just take one minute.
Sure.
So, my lord, we are on the limited question, my lord, today, my lord. I am challenging the award on this limited aspect only, my lord. Whether the arbitrator has proceeded on the right direction by ignoring the date of breach altogether. And that is a new case which he has made for the parties. Firstly, it is prohibited by law. Secondly, my lord, that is also not their case. And he has sought to make a distinction between and given some credence to a statutory authority, my lord, which is not permissible. So, my lord, I was showing your lordship this paragraph of the award. "177 I had placed and 178.
174 also, issue number 5 you were reading? Then
Yes, from 174, in
Or
fact,
on-
I have started.
Yes,
Issue number 5 is what I am concentrating on.
yes.
The conclusion in issue number 5, my lord, I am emphasizing on 177 and 178.
Yes.
So, my lord, I start with the judgment relating to the computation of damages on the date of breach. That cannot be altered by court. প্রথমে 61 টা দেখি 61 SCC online. Yes. এই তো This is 1960 AIR 62 Supreme Court 366 1961 SCC online SC 100. So, my lord, kindly see the facts at the beginning, my lord. It's a suit was filed by the firm measures such and such against Chiranjit Lal. Case was that a contract had been entered into between the appellant and the respondent through Babulal for sale of certain canvas at ₹1 per yard. The delivery was to be made through railway receipt for Calcutta, FOR Kanpur. Then, my lord, kindly see 2 lines from the bottom, my lord. Appellant failed to deliver the railway receipt. Informed the respondent on August 8, 1947 that as booking from Kanpur to Calcutta was closed, the contract had become impossible for performance. Consequently, appellant cancelled the contract and returned the advance that had been received. The respondent did not accept that the contract had become impossible for performance, informed the appellant that it had committed a breach of the contract and was thus liable in damages. Now, so this is a similar case. Now, I come straight away to the point where the damages have been discussed. Kindly come to paragraph 6. The same 2 questions which were in dispute before the High Court have been raised before us on behalf of the appellant. We think it is unnecessary to decide whether the contract had become impossible of performance, as we have come to the conclusion that the appeal must succeed on the other point raised on behalf of the appellant. Next, my lords. Necessary facts in this connection are these. Contract was to be performed by delivery of railway receipt of FOR Kanpur by the appellant to the respondent on August 5, 1947. This was not done. There was undoubtedly a breach of contract on that date. Question therefore arises is whether respondent has proved the damages which it claims to be entitled to for the breach. Respondent's evidence on this point was that it proved the rate of colored canvas in Calcutta on or about the date of breach. This rate was such and such per yard, and the respondent claimed that it was therefore entitled to the damages at the rate of such and such per yard, as the contract rate settled between the parties was ₹1 per yard. Quantum of damages in a case of this kind has to be determined under Section 73 of the Contract Act. Then, my lord, Section 73 is quoted. My lord, this line is very important. When a contract has been broken, party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach. This is the first part. Or which the parties knew when they made the contract to be likely from the result of the breach of it. In estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by non-performance of the contract must be taken into account. This is what you have done to mitigate the possible loss which you have suffered. That has to be considered, has to be taken into account. Kindly see, my lord, paragraph 9. The two principles on which damages in such cases are calculated are well settled. The first is that, as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed, as far as money can do it, in as good a situation as if the contract had been performed. This is the principle of restitution. But this principle is qualified by a second, which imposes on a plaintiff the duty of taking all reasonable steps to mitigate the loss consequent on the breach, and debars him from claiming any part of the damage which is due to his neglect to take such steps. This was what I was harping on, my lord. This is quoted from the famous English judgment of British Westinghouse. These two principles also follow from the law as laid down in section 73, read with the explanation. If, therefore, the contract was to be performed at Kanpur, it was the respondent's duty to buy the goods in Kanpur, rail them to Calcutta on the date of breach, and if it suffered any damage thereby because of the rise in price on the date of breach, as compared to the contract price, it would be entitled to be reimbursed for the loss. Even if the respondent did not actually buy them in the market at Kanpur on the date of breach, it would be entitled to damages on proof of the rate for similar canvas prevalent in Kanpur on the date of breach. Therefore, it would obviously be not entitled to any damages at all, for on this state of evidence, it could not be said that any damage naturally arose in the course of things. So, my lord, this is the principle. Wherever the contract was to be performed, you would have to take necessary steps to minimize that loss. And still, if you have taken those steps, then you have still suffered a loss, then you will be entitled to the difference. Right? Both these parts are important, but if therefore the contract was to be performed, it was the respondent's duty to buy the goods in Kanpur, rail them to on the date of breach, and if it suffered any damage thereby because of the rise in price on the date of breach as compared to the contract price, it would be entitled to reimburse for the loss. So, my lord, this issue is directly involved in the present case.
Yes.
Now, kindly see how the learned arbitrator, my lord, clearly makes a departure from this principle. I'll just say, my lord, from page 175, second paragraph, to just show, my lord, where it has, my lord, gone contrary to the principle of 73. Second paragraph, your lordship will see the JCI has claimed that they have suffered loss as due to recession, the price of jute has decreased from September 2006. They have claimed that price of jute was 1340 per quintal in September 2006, which has decreased to 1140 in January 2008. So this January 2008, where does the respondent get it? When, according to the contract, the breach has already occurred in November. And in November, if you had sold it, would you have suffered any loss? Because that is the basis on which I have said that I am not in a position to give you any further money.
They are saying that on the date of filing of this claim.
That is the problem. That cannot be done. But that is absolutely contrary to 73. I have committed a breach today. You will wait for 5 years, 3 years, because 3 years is the limitation period, and 3 years, the moment the prices where there is a differential, you will file and say that on the date of the claim. That is not the principle. Because you have suffered not then, you have suffered now. That is the principle that this is a conceptual error. An absolute conceptual error. The law is very clear on this. It's not that it will be requiring a lot of interpretation. They are saying filing of statement of claim here, but the arbitrator's reasoning is also not in accordance with the principle. The arbitrator says that I have given them time for 4 months because 4 months is reasonable within which they could have taken any action. What prevented them from taking any action then? Because then there was no any price difference, and that is what we have disclosed also before the arbitrator. That what was the price as on November 2008? Documented happen.
How much time are going to take, Mr.
I'll take half an hour.
And you?
Lord, I shall take around an hour.
Sorry?
Lord, an hour or so.
Then Mr. Saha.
Shall we come back?
You are in the next matter.
Yes, that ITD. Yes.
You are also there?
Yes.
So that we'll have then tomorrow. Because this will be good for the day then.
Tomorrow.
Lord, may I come back tomorrow after my learned senior friend completes? Lord,
why?
Lord, my learned senior friend is showing judgment. Lord, allow me some time to come back on those.
This way, so we'll never finish any of the.
Lord, I'll complete my submissions. Lord, an hour. Lord, I'll take an hour.
But anyway, your lordship will be taking up non-commercial also.
I want to finish it. It is, part-hearts, and the problem is then it gets stuck, and if it's stretches out for too long,
The
then
34, my lord, it will take it. But
that's why I'm here to do these 34. So
my lordship will keep the 34 12 noon onwards. From the 12 noon.
Generally, that's what I do. 12:30 onwards, I'm trying to do it.
Because the smaller matters, motions, your lordship
12:30 motions, I try to finish it off so that I keep these after 12:30 onwards.
I also have some matter now.
Mr. Singh, finish this off.
I'll come back tomorrow. Next judgment, my lord, this is also on the same point that a person who is claiming the damage cannot postpone his damage to at a later date to get a favorable market. Now, this, my lord, is a Madras High Court judgment. It's a division bench, and on this principle, my lord.
আমার কাছে তোমার mark করা আছে। হ্যাঁ, তোমারই mark করা আছে।
मुझे বার করা মুশকিল।
Which page? Which
kindly come to the first paragraph itself. Kindly see, my lord. First paragraph, third line. The plaintiff filed a suit for a recovery of 43,875 and cost, which according to him was damages payable by the defendant consequent upon his non-performance of a major portion of 3 agreed contracts he entered into according to him on 15 November 69, 16 December 69 and during the 3rd week of January 72. Plaintiff's case is that the defendant is a manufacturer and dealer of empty tin containers, and he being dealing in groundnut oil, refined oil, placed orders on 3 dates for supply at 3 different prices for varied quantities, and those contracts are evidenced in writing excepting last of them, and defendant accepted such contract but failed to perform the same in full. This is a case of a seller's breach. Buyer is suing. Defendant accepted but he failed to perform the same in full, and therefore he was entitled to claim such damages which flew from the breach of contract committed by the defendant. The defendant's case is that it was no doubt true that the first 2 contracts were entered into under dates specified by the plaintiff in the plaint, but insofar as the third is concerned, there was no written contract, but only his further claim kindly note this, is that from time to time plaintiff injuncted him from performing the contract on the ground that he had sufficient stocks of tin, on the ground that the demand had come down and therefore he could not perform the agreed contracts. So this was the case, my lord. Then kindly see towards a little lower down on the same paragraph. Issues were framed, number 3, to what damages is the plaintiff any entitled to. Thereafter, your lordship will kindly turn the page to kindly come to paragraph paragraph 10 at page 498. Paragraph 10, kindly see the last line, the question therefore. The question therefore is whether in the circumstances of this case and generally whether a buyer can on his own volition postpone the demand for performance in the absence of any time for performance to an unreasonable and illogical extent so as to enable him to claim such performance at a time when it is most advantageous to him. In our view, the buyer cannot adopt such a self-serving policy. The plaintiff himself was not keen upon performance, but he was further interested in part performance of the contracts. He would ask only for 1 wagon or 2 wagons in his correspondence and would on more than one occasion say stop dispatch. In such circumstances, the plaintiff buyer cannot of his own and to his advantage pick and choose the time for performance. What prompted the plaintiff to keep silent without furthering the instructions given under Exhibit B9 is not at all explained. In such circumstances, it would be highly inequitable and unjust to accept a claim for compensation or damages on the part of such a self-interested buyer who postpones the demand for delivery without cause, but obviously with intent to gain a material advantage to him. As early as 1912, this principle in a different form was settled by the division bench of our court. Section 63 of the Contract Act does not entitle a promisee for his own purpose and without the consent of the promisor to extend the time for performance which had been agreed by the parties to the contract. Section 55 of the Contract Act does not enable the promisee to say that he elected to keep alive the contract in the hope of being able to claim heavier damages for breach of the contract. Section 63 only deals with only concessions on the part of the promisee advantageous to the promisor. Section 55 read with 2(1) relating to revocation of the contract only means that the promisor loses the power to enforce the contract, that is, to claim any advantage due to himself thereunder. The promisee may enforce it or not as it suits with him. In case he enforces it, he can sue for damages naturally resulting from the breach, which cannot include any aggravation of damages caused by the promisee's action or inaction subsequent to the breach. We respectfully adopt the principle stated above. In the case, plaintiff has ample opportunity to treat the defendant in breach. He did not do so prior to 1st of March 1970. On the other hand, he was asking him to stop supplies, and after 1st of March, a controversy arose between the parties regarding payment. Suffice as it at this stage to say that the plaintiff has unilaterally postponed his right to claim performance, and he cannot take advantage or undue benefit out of such a voluntary act on his part and take advantage of a favorable market. So, my lord, why I place this is because of 2 documents. Number 1, November, my lord, 2016, I had already intimated to him, my lord, that particular document, if your lordship will see.
Page 16.
Yes. November 2006. Yes. Kindly see, my lord. First is 60 days expiry on 8th November 2006.
Page?
Page 60.
Yes.
from the contract clause, I had shown the 60-day period where the contract will stand rescinded. That is the clause 6 of the contract, 6.4.
Yes.
After that date, immediately I had given this letter. So, my case is that if at all a breach has occurred, then the contract stood rescinded by breach on this date. Now, what is the stand of the claim respondent here? Kindly see, my lord. Their stand is first time it is coming in 52, June 2007. After 8 months in June 2007, this is their stand. As if to say the contract is kept alive by them. This is what, my lord, this division bench says that it is not permissible.
Page 60, we say that it's without any market difference, specifically.
There, kindly see the last paragraph. We therefore lastly request you to make immediate payment arrangement for delivery of balance quantity, otherwise action shall be taken as per terms of contract. So you are saying, though the contract says it has expired within on 68th day, that is reinforced by my letter that I am not in a position to perform. Whatever view the court takes of it, the contract cannot remain alive at your instance after that date. And if you have kept it alive, it is only with a view to claim a higher damages on account of favorable market. This is the principle which I am actually arguing. I do not want to multiply on this, but this is the basic principle under section 73. Firstly, there is no mitigation. Secondly, the computation on a date after the breach is fallacious. Next I show 2023. 2023. 23 টা দে। 23/9. Kindly take 2023 9 SCC.
Para 20.
ঠিক আছে, বলো 500 নিতে, কাউকে দাঁড়াতে বারণ করো, 500 হবে। Kindly see, this is also a sales contract. Kindly see a bit of the facts. Paragraph 3, MMTC, that is at page 426. MMTC entered into an agreement dated 14th January 1986 with Baker for purchase of US origin sulfur. Terms of the agreement was such and such. This then paragraph 5, quantity of 50,000 metric ton of sulfur was not lifted by MMTC. Instead, MMTC by fax informed Baker that import of sulfur was decanalized by the Union government. It could not nominate any vessel. Baker did not accept the MMTC's reason for lifting. This is the then there is a ultimately paragraph 6. They have Baker has terminated, claimed damages for past 3 half-yearly semesters, January to June, July to December, and January to June 1993. Now, kindly come to the finding of the court. Paragraph 9, your lordship will see. In arbitration, Baker contended that MMTC had committed breach for purchase of 50,000 metric tons during the period January to June 92. Baker claimed damages for MMTC's failure to lift sulfur during the second half of 92 and 2 half-yearly semesters of 93-94. 3-member tribunal held breach has been committed. Then, during the first of 1992 remained intact. The single judge found that this plea was justified, upheld the tribunal's finding for award of damages for the period January to June and for the balance period June to December. Damages for the latter period was set aside. Now kindly come to paragraph 22. No, I'll show from paragraph 17. As far as the second aspect, that is damages payable for breach of contract for the later period is concerned, this court notices that although MMTC claims that Union government had directed canalization on 29th February 92, this communication was addressed to Baker on 8th April 92, not immediate. Before the tribunal in the arbitration proceeding, MMTC made no attempt to produce a copy of the canalization order. The least expected of MMTC was to intimate Baker that the alacrity required that at the earliest point of time in March 1992, expressing its inability to continue with the arrangement. It did not choose to do so and waited till April to share with Baker that a decanalization order has been issued. Its reason for not lifting the goods was attributed to decanalization again on 31st August 1992, when MMTC intimated to Baker that the decanalization order had resulted in large sulfur consuming units importing sulfur from Gulf countries where the landing cost was much lower than the landing cost sulfur from US, such and such. Again, nothing prevented MMTC, at least from the record, and nothing was shown to prevent it from communicating this aspect at the earliest point of time for Baker to have made alternative arrangements. For these reasons too, the award for the previous period does not call for interference. Turning now to the award for the balance period, that is July to December 92, there cannot be two opinions about the fact that measure of damages has to be in accord with the provisions underlying 73 of the Contract Act. That is market price of goods on the date of breach, less contract price. The division bench, after noticing the record, held that Baker had clearly shown its disinclination to negotiate the price for second half of 1992 before resolving the shipping problem in that period. In these circumstances, there was no negotiation and no attempt made on its behalf to contact MMTC after April 92, save a few letters. This formed the only basis for the grant of award for the second half to the extent of US dollars 3 lakhs. The tribunal had noted such and such. Now, my lord, your lordship will kindly come to paragraph 22. No, 21 also. 21 also. The failure to produce the best evidence that Baker possessed in the form of contracts for balance quantity and payments received as proof of damages suffered and shipping arrangements in question, as well as shipments billed from time to time with full particulars, in the division bench's opinion, disentitled to any compensation for the latter period, given that it was made well aware in April 92 that arrangement could not be continued by MMTC. Findings of the division bench are therefore in accord with law. It is undeniable that measure of damages as per section 73 of the Contract Act is the difference between the price at which goods sell at the marketplace on the date of breach and the contract price. But then, my lord, this 62 Supreme Court has been quoted, Murlidhar Chiranjilal, which I, my lord, I have placed. Paragraph 13 has been quoted. In that case, the seller failed to prove the price of goods on the date of breach at the place of delivery. Court refused to award compensation. In the present case, this court holds that the impugned judgment applied, partly setting aside the award. So, my lord, that is the principle, my lord, which we are also urging here.
So that this means the respondent had to prove that a market trader come from the date of the breach for similar goods that gone above the contract rate. So be damages from.
My lord, kindly here, my lord, why I am relying on this is, my lord, kindly see the principle of mitigation is also noticed in para 21. That the non-defaulting party, he did not produce the evidence to say what contracts he had and what is the payments which he received for to compute the losses suffered.
No evidence was there.
So here also, my lord, though the arbitrator Suomoto grants them 4 months' time, as if, my lord, they could have taken steps within that period, but there is nothing on record at all that whether such steps were taken by them and they could not recover that price. আর কোনটা আছে?
79.4 SCC 321.
79.4 SCC, yes.
35.
Yes. Kindly take, my lord, 1979, volume 4, SCC 351. Non-delivery of goods by the seller. Kindly see paragraph, it says 1A. Kindly let us come to, my lord, straight away to the, this again, my lord, on the breach under section 73, kindly come to paragraph 26. No, before that, kindly come to paragraph 11, the question. Kindly see in paragraph 11, ascertainment, second line, ascertainment of the plaintiff's claim for damages turned on a determination of 2 points. What was the condition of goods at the time of sale in favor of the plaintiff? What was the market value of the goods of that quality and condition in August 1950 when the alleged breach of the contract took place? Kindly thereafter straight away comes to 26. It is clear from the above conspectus that the evidence produced by the plaintiff was not cogent, convincing, and reliable to establish either that the goods comprised in lot number 32 were in brand new condition or market price of the goods of similar specifications in August 1950. In view of the circumstantial evidence on the record, the court below was not wrong in holding that the market price of the goods in question in August 50 was the same at which they were purchased by the plaintiff from Tulsiram Bhagwan Das, and consequently the plaintiff was not entitled to any damages apart from the refund of the money paid, 35,200. So, my lord, if I apply this principle to this award, my lord, the following are the apparent errors on the record. Number one, my lord, is the court has not proceeded on the date of breach.
60 days.
Number one, the court has proceeded on the date. Firstly, the plaintiff, the claimant has proceeded on the date of filing of the statement of claim, which is not in accordance with section 73. The tribunal goes to a step further and takes a mid path, says 4 months after the breach has occurred,
Reasonable period.
with saying that it is a reasonable period. That cannot be granted. Now he went on a proposition and a supposition. So Lordship will see page 178 why he has taken 4 months time. He says, Lord, that it could be that 178 at the top, it could be that the price of jute which had fallen would rise again, and as such it was prudent to wait and see for a reasonable time. Now, this is not like a share market, fluctuating prices. This is something like a regular market. It is a regular market. Tea, jute, these are all controlled regular markets. Time of the year when there is the harvest is there is a certain market, and the price again falls when the season is a new fresh season. So as the jute corporation, they are well aware of the trend. As on November, what is the trend? As on June, what is the trend? So therefore, my lord, this is contrary to even the available market for the particular goods in question. And then he gives a reason that I consider 4 months time should be held reasonable. So this is again not even the claimant's case. Claimant's case has not been accepted, which is contrary to 73. The arbitrator says that it should be on November, but I will give 4 months time. I think this is
There are two claims.
now
One is
the
carrying
next,
charges.
the other claim is on account of carrying charges. Carrying charges also, your lordship will find same thing. Kindly come to 180. There, the carrying charges have been dealt with. Claimant has claimed storage carrying charges at the rate of 25 per quintal, which is clearly enumerated in the contract. Yes, that is true. Moreover, in another award delivered by another arbitrator, question whether JCI could claim carrying charges was decided. It was held by the arbitrator that JCI is entitled to claim the same. Above award passed by such and such has been admitted in evidence. There is no evidence here. I fully agree. In view of the above, I hold that the carrying charges are payable to JCI and have to be paid by the concerned jute mills. Since I have held that the reasonable time of this is where I join issue here. Since I have held that reasonable time of disposal should be 4 months. Here again is the fallacy.
6.2 say.
If your lordship sees the clause, I rely on the clause. I say that if he had gone by the clause, then the 4 months could not have been taken. Your lordship will kindly come back to that clause.
41,
Page 41. No, carrying charges is not 41.
No,
Carrying charges, kindly come to 4.7. That is 40. Clause 4.7. Other defeated. But the LC contract will store. Kindly see 4.7. The SCI reserves the right to recover the carrying charges and other incidental charges at the rate of 2% of contracted value or 25 per quintal per month. So, it depends on, again, the date of breach. Per month quantification per quintal is 25, no doubt, no dispute. So, till which period you will charge the carrying charge? It has to be the date when the breach is notified. So, there, this 4 months cannot come in at the most. If he had come to the conclusion that the breach has occurred on November 22nd, then it has to be up to November from the date of the contract. Unfortunately, he has gone proceeded on the basis of 4 months. Of course, in this jurisdiction, this error cannot be corrected. This is a fallacy. This is contrary to the contract and the principle. This much is my argument. In the summarizing my arguments, I say, the award stands out within the scope of the present act to be contrary to law. That is fundamental policy of India. Substantive law. So, applying the principles of Sangyong, this award falls within your lordship's scope of intervention under section 34. It is clearly contrary to the substantive law of the country. You cannot, it's not like erroneous application of the law. It is contrary to the substantive law.
And contrary to contract. Sangyong paper দেখে দেবে
দেখে না ওরা দেখাবে না কি দেখাবে
Sangyong তো দেখি
I just show Sangyong judgment which has summarized the principle.
Everything.
One particular portion, taking the principle of associated, it has culled down. After amendment, what remains as the grounds?
There are 34 together.
Barcode?
33, 34. 34.
Yes. Kindly come to paragraph 34.
এখানে associated discussion গুলো আছে পর থেকে আছে associate
Yes,
builder
yes. Starts from 34, my lord. What is clear, therefore, is that the expression public policy of India, whether contained in section 34 or in 48, would now mean fundamental policy of Indian law as explained in para 18 and 27 of associate builders. That is, the fundamental policy of Indian law would be relegated to the Renusagar understanding of the expression. This would necessarily mean that Western JECO expansion has been done away with. In short, Western JECO has been explained in para 28 and 29 of associate builders would no longer obtain as under the guise of interfering with an award on the ground that the arbitrator has not adopted a judicial approach. The court's intervention would be on the merits of the award, which cannot be permitted post-amendment. However, insofar as principles of natural justice is concerned, as contained in section 1834 to A3, these continue to be grounds of challenge.
Basic notions of
Now,
morality,
kindly come to
equality.
36. Thus, it is clear that public policy of India is now constricted to mean, firstly, that a domestic award is contrary to the fundamental policy of Indian law, as understood in para 18 and 27 of associate builders, or secondly, such award is against basic notions of justice or morality, as understood in 36 to 39 of associate builders. Explanation 2 to section 34b2 and explanation 2 to section 4 is added by the Amendment Act only, so that Western JECO, as understood as para 28 and 29, is now done away with. Insofar as domestic awards made in India are concerned, an additional ground is now available under subsection 2 capital A, added by the Amendment Act 2015 to section 34. Here, there must be patent illegality appearing on the face of the award, which refers to such illegality as goes to the root of the matter, as does not amount to mere erroneous application of the law. That is to say, my lord, subject to correction, a judgment is being wrongly construed and applied, but not the substantive law. You cannot go against the substantive law of the country. In short, what is not subsumed with the fundamental policy of Indian law, namely the contravention of the statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patently illegality. Secondly, it is also made clear that we are not going into. I have not gone into evidence at all.
Because there is no evidence led by them as such.
Firstly, there is no evidence, and I have not also tried to reappreciate any documentary evidence either.
Point of contrary to contract and point of
Yes.
Substantive.
Also, 41, your lordship will see. What is important to note is that a decision which is perverse, as understood in para 31 and 32 of associate builders, while no longer being a ground of challenge under public policy of India, would certainly amount to patent illegality appearing on the face of it. Finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. Other grounds may not apply in my case, but we rely solely on the principle of non-application, non-consideration of the principle of section 73. I think these are.
4 months were taken by arbitrator's presumption.
May I come back tomorrow? Or may I start or may I come back tomorrow?
No, start.
Or perhaps I will not be able to finish today.
Start it.
So before taking to your lordship to the facts, my lord, I will start with the law. Now, my learned senior friend has taken your lordship to the entire documents before the arbitral tribunal. Lord, I shall restrict myself to section 34 of the Act.
I'll just take your lordship.
If my lord kindly takes up section 34. Look, from what I could understand, look, the challenge to this award is only on two grounds. Firstly, under 34(2)(b)(2), that is, the arbitral award is in conflict with the public policy of India, and 34(2)(a), an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Lord, I would like to read the explanation along with 34(2)(b)(2). For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if 1. The making of the award was induced or effected by fraud or corruption, or was in violation of Section 75 or 81, which in the present case, my lord, perhaps is not what they are arguing. 2. It is in contravention with the fundamental public policy of Indian law. My lord, this they have argued. 3. It is in conflict with the most basic notions of morality or justice. Now, that has not been placed. So we are only dealing with fundamental policy of Indian law. Lord, what is fundamental policy of Indian law is explained in explanation 2. For the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Lord, my learned senior friend has taken your lordship to the entire arbitral record, back and forth, all the documents, to say that there is fundamental policy, breach of fundamental policy. Lord, this is in complete contravention to the explanation. Now, Lord, section 34(2)(a). An arbitral award arising out of international commercial, other than international commercial arbitration, may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Not the proviso. It qualifies that, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Lord, both of which have been argued and pleaded by my learned senior friend. So, my lord, both these grounds for setting aside do not involve reappreciating the evidence, arguing on the merits of the dispute, and then by a process of reasoning, arguing that the arbitral award is bad and liable to be set aside. Lord, for this proposition, my lord, I shall hand over a judgment of the Honorable Supreme Court by a 3-judge bench. My lord, Sangyong was by a 2-judge bench. Now, this is 2025, volume 2, page 417. Lord, kindly comes to paragraph 30. Before we delve into the sub-issues culled out above, it would be useful to have a look at the relevant legal principles governing a challenge to an arbitral award. Recourse to a court against an arbitral award may be made through an application for setting aside in accordance with subsections 2, 2A3 of the 96 Act. Lord, I'm skipping a few. Then, Lord, what is fundamental policy of Indian law is explained in paragraph 51 and 55. As discussed above, till the 2015 amendment, the expression in contravention with the fundamental policy of Indian law was not found in the 96 Act. Yet in Renu Sagar, in the context of enforcement of a foreign award, while construing the phase contrary to public policy, this court held that for a foreign award to be contrary to public policy, mere contravention of law would not be enough. Rather, it should be contrary to A, fundamental policy of Indian law, and or the interest of India, and or justice or morality. Now, Lord, paragraph 55.
Paragraph 50?
55 and 56. Now, what is the fundamental policy of Indian law now after the amendment? The legal position which emerges from the aforesaid discussion is that after the 2015 amendments in section 34(2)(b)(2) and 48(2)(b) of the 96 Act, the phrase "in conflict with the public policy of India" must be accorded a restricted meaning in terms of explanation 1. The expression in contravention with the fundamental policy of Indian law by use of the word fundamental before the phrase policy of Indian law makes the expression narrower in its application than the phrase in contravention with the policy of Indian law. Which means mere contravention of law is not enough to make an award vulnerable. To bring the contravention within the fold of fundamental policy of Indian law, the award must contravene all or any of such fundamental principles that provide a basis for administration of justice and for enforcement of law in the country. Without intending, paragraph 56, without intending to exhaustively enumerate instances of such contravention by way of illustration, it could be said that A, violation of principles of natural justice, B, disregarding courts, orders of superior courts, or the binding effect of the judgment of a superior court, and C, violating law of India linked to public good or public interest are considered contravention of the fundamental policy of Indian law. However, while assessing, this is important. However, while assessing, there has been a contravention of the fundamental policy of Indian law. The extent of judicial scrutiny must not exceed the limit as set out in explanation 2 to 34b2. That is not going into the merits of the dispute. This is with respect to fundamental policy of Indian law. Lord, on patent illegality, Lordship kindly comes to paragraph 65. Lord, both points have been argued by taking your Lordship through the documents back and forth. Lord, under both the grounds, this is impermissible. Lord, paragraph 65. Subsection 2A of section 34 of the 96 Act, which was inserted by the 2015 amendment, provides that an arbitral award not arising out of international commercial arbitrations may also be set aside by the court if the court finds that the award is visited by patent illegality appearing on the face of the award. The proviso to subsection 2A states that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. In saw pipes, Lord, I'll skip this paragraph, paragraph 68. In Sangyong, this court specifically dealt with the 2015 amendment, which inserted subsection 2A in section 34 of the 96 Act. It was held that patent illegality appearing on the face of the award refers to such illegality as goes to the root of the matter, but does not amount to mere erroneous application of the law. It was also clarified that what is not subsumed within the fundamental policy of Indian law, namely the contravention of a statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patent illegality. Further, it was observed that reappreciation of evidence is not permissible under this category of challenge to an arbitral award.
Rest tomorrow. We'll have non-commercial matters for some time.
Great. Lord, I shall continue with this judgment.
Yes. Non-commercial.
I have not gone on merits actually. I have said 73 principle is not fulfilled, nothing more.
Heard learned senior counsel, Mr. Shakya Sen and Mr.
Aman Agarwal.
Aman Agarwal for the respondent, listed for further hearing tomorrow. We'll try to finish it tomorrow.
I'll give a reply, a short reply. No, facts, I will not be giving anything reply. If they cite any other judgment, I will deal with it.
Facts we are not supposed to look at.
Yes, yes, we are not supposed to go.
Non-commercial ले लेना कुछ थोड़ा.
ये देवे 181 and 180. Awarded like page 181 and 182 is missing there.
Item
Item number 1. Daily item number 1. 130 of
You're there? Item 1.
Number 2.
Tata Capital Financial Services. Item 1. Item 1, you're there, no? Take down. Learned counsel for the petitioner seeks to withdraw the present petition in terms of the amicable settlement arrived at between the parties.
Lordship, I am handing over the written instruction.
Written instruction received from the client to withdraw the present petition in terms of the settlement is taken on record. Petition is dismissed as withdrawn. All interim order stands vacated. Okay?
For the judgment determination.
I appeal for the award holder, Lordship. This is the execution. I am led by Mr. Shurit.
I file an opposition, my lord, to the supplementary affidavit filed by my learned friend, my lord.
কবে দিয়েছে?
What are your instructions?
But I have filed an opposition to the supplementary, my lord. Instruction is that, my lord, according to us, my lord, the entire amount has been paid. What discrepancy is there, my lord? The department deducted the TDS. On that amount, my lord, they are asking for interest. Well, according to, my lord, the departmental instruction, or department supposed to, my lord, deduct the TDS.
Department is not supposed to interpret the award, sir.
No, my lord, if your lordship takes up the award,
Yes.
then, my lord, in award, my lord, we have also stated there, my lord, if your lordship, my lord, takes by my opposition.
এটা হচ্ছে টিডিএস কেটেছে।
না, এটা TDS। হ্যাঁ,
না,
ঠিক, ঠিক, correct,
TDS
correct,
কেটেছে।
ঠিক।
দিলাম সম্বন্ধে কোথায় বলি?
TDS কেটেছে?
No,
এটা একটু এটা
my lord,
TDS
kindly
একটু
take
বেশি
up, my lord, the
আমরা
opposition at page 3.
TDS কেটেছে 54
কেটেছে।
7 লাখ। 7 লাখ। হ্যাঁ, এটা তো অবশ্যই TDS কেটেছে।
এটা তো দিল।
এটা দিল, এটা কেটে এটা দিল।
Yes.
8 লাখ।
My lord, kindly
25
take, my lord, para 4, my lord. There, lordship will find, my lord, we have quoted from the award, my lord. Clause 15. Considering the facts and circumstances of the case, the documents and correspondences exchanged between the parties in submission advance supporting their claim and defense, and the decision cited, it appears the tribunal that the claim of the claimant in this reference could not be disputed, disapproved by the respondent. This tribunal accordingly hold the respondent liable to pay claim of the claimant made in proceedings in sum of rupees 58 lakhs, as detailed in para 22 of associates, my lord, statement of claim. And also rupees, my lord, 2 crores 54 lakhs 37,533 as pleaded in paragraph 29 of the statement of claim. Then, my lord, kindly turn the pen, my lord, kindly come to, my lord, next page, my lord, page 4, my lord. In so far as the claim of the interest made by the claimant at the rate of 12.5% per annum, this tribunal finds and holds that there was and is no agreement between the parties for payment of interest for any sum due and payable by one party to the other. However, the respondent, being a government authority holding the occupation of the premises upon expiry of the lease, and vacated the occupation and handed over possession to the claimant much after issuance of notice to quit, the tribunal holds the responsible liable to pay interest at the rate of 10% per annum on the sum due mentioned in prayer A and B of the statement of claim from 1st July 2021 till the date of this award. It is noticed that the claim on account of unpaid rent, short paid rent, and mean profit are calculated at the rate of 68.34 per square feet per month as assessed and determined the surveyor valuer.
Well, paragraph 7, insofar as the claim for service tax as prayed for in the prayer 1 of the SOC is concerned, the tribunal hold that the respondent is also liable to pay 55 lakhs, 55,639 as prayed for in prayer 1 of the SOC, but without any interest. On account of cost incurred, the parties were directed to submit their chart. Then, my lord, kindly turn the page, my lord, kindly come to my lord, page 5. The arbitral tribunal allows the cost in favor of the claimant assessed at rupees 87 lakhs and holds the respondent liable to pay the same to the claimant. The respondent is therefore directed to pay arbitral award within a period of 4 weeks from the date of this award, failing which they shall pay further interest at the rate of 12% per annum on the arbitral award until realization. Then, my lord, subsequent thereto, my lord, an application was made by the my lord claimant, and my lord, additional award was published. Paragraph B, my lord. Thereafter, an additional award was made and published by the learned arbitrator on 28 February, March 2024 in arbitration between the parties hereto. By the said arbitration award dated such and such, the learned was pleased to direct the award debtor inter alia that according to the application is allowed, the tribunal mistake crept in the paragraph 16 of the award 24th January is corrected. The original award, paragraph 16 of the award is thus substituted. Then the substitute paragraph is quoted there, my lord. In so far as the claim for interest made by the claimant A at the rate of 12.5% per annum, this tribunal finds and holds that there was and is no agreement between the parties for payment of interest for any sum due and payable to the parties. The respondent government, my lord, I'm skipping over. Ultimately, the tribunal holds the respondent liable to pay interest at the rate of 10% per annum on the sum due mentioned in prayer A and C of the SOC. Well, earlier it was A and B, subsequently corrected by A and C, and 10%, my lord. Then, my lord, I have, my lord, detailed breakup has been given, my lord. If you lord still text up the breakup at page annex A, my lord.
Okay.
My lord, kindly come to page 13, my lord.
Yes.
My lord, kindly, my lord, text up the, my lord, chart detail has been given, paragraph page 13, my lord. My lord, number 1, as per clause 15 of the award, my lord, the rent was due was 58 lakhs and odd, my lord. Then, my lord, as per clause 15 of the award and para 29 of the SOC, my lord, the main profit was 2 crores 54 lakhs and odd. Then, my lord, as per clause 16, my lord, 10% interest was awarded. That was, my lord, 58 lakhs and odd, and comes to, my lord, this amount. Then, my lord, as per clause 16, it was corrected by the subsequent, my lord. Then interest came to, my lord, 69 lakhs. And unpaid service tax is, my lord, 55 lakhs. Annually cost is 87 lakhs. All total came to, my lord, 5 crores 40 lakhs 68,435. And, my lord, TDS they are deducted only 54 lakhs, and payment was made only 4 lakhs 86,61,000. Then, my lord, kindly come down on interest calculated, my lord, on 5 crores 40 lakhs, my lord, 482 days, my lord, 12% per annum. The interest was calculated 85 lakhs 67,000. That was paid, my lord, subject to deduction of TDS. Now, my lord, due is remain only in respect of TDS. Otherwise, my lord, interest has been paid. Now, my lord, what they have claimed in their supplementary video, if lord single takes up, my lord, kindly sees, my lord. They are, my lord, kindly come to page 7.
Supplementary affidavit.
It was 12th November 2025. My lord, page 7 kindly sees, my lord. Awarded amount, my lord, principal, that was 5 crores 40 lakhs. My lord, including all, my lord, main profit, rent, interest, total comes to, my lord, 5 crores 40 lakhs. Now, my lord, paid on, my lord, 4 crores for 86 lakhs, deducting TDS 54 lakhs. My left hand side, my lord, column number 3. Then, my lord, interest paid, my lord, 85 lakhs as per award, my lord. Then, my lord, that was paid subject to deduction of, my lord, TDS. That was 8 lakhs 56,000. In fact, my lord, interest paid on 77 lakhs. Then, my lord, kindly column 6 kindly sees, my lord, they are calculating interest on principal. That is 3. My lord, 3 kindly sees, my lord,
3 is the TDS. And TDS is deducting from entire amount, my lord, including interest also, my lord. 5 crores 40 lakhs, I have, my lord, given the detailed breakup in my opposition. You also will find there, my lord, including interest, 5 crores 40 lakhs.
Yes.
My lord, they are treating this TDS as a principal, my lord. And on that account, well, they are asking for 12% interest. But in the award, it has not been quoted anywhere that they are entitled to get interest on interest, my lord.
Yes.
And my lord, what happened here, my lord? Then they totally calculated and minus 2 plus 5, 1 plus 4 plus 6, and 2 plus 5, then comes to the 64 lakhs. My lord, only they are asking, my lord, main thing, my lord, 1,88,000 they are asking. Clause 6, kindly serial number 6, kindly sees, my lord. Other amount has been paid because, my lord, TDS has been deducted and it has, my lord, go to the account of the, my lord, deposit to the account of the, my lord, judgment degree holder. Award holder, my lord. Now they are asking for interest, my lord, on the, my lord, TDS amount.
So, Mr. Mitra, according to them, they have made the payment. It is only on the TDS that you are claiming.
I'll show your lordship.
One more thing, if I complete, my lord. If your lordship, my lord, takes up my opposition, they are what they have stated in their earlier supplementary affidavit, my lord. Kindly seize, my lord. My lord, 24th July 2025, my lord, on supplementary affidavit they have affirmed.
Page number internal page 6.
My lord, kindly come to internal page 6, my lord, paragraph 13. In view of the above, for the sake of adjusting the amount of rupees 5 crores 40 lakhs, which the award debtor had undertaken to pay to the award holder out of the awarded sum, the correct amount payable after deduction of TDS should have been a sum of 4 lakhs 92,000, 4 crores 92 lakhs. And therefore, sum of such and such is still. Then, my lord, kindly come to, my lord, paragraph 15. Therefore, the award debtor is liable to pay the award holder interest 12% per annum on the principal sum, and will ultimately calculated in 82 lakhs 3,226, whereas we have paid 85 lakhs as per our calculation. Therefore, my lord, it is within his knowledge that TDS was deducted, and they admitted in by affidavit saying that it is actual amount is payable after deduction of TDS. That is their affidavit, my lord.
Yes.
Upon due respect to the order passed by this court, from time to time, we have paid entire amount subject to the deduction of the TDS. Otherwise, nothing is due and payable. And they are calculating interest on interest, my lord, treating the TDS as a principal, and on that amount they are paying, my lord, 12% interest.
Yes.
Sir, kindly take up their chart. And my supplementary affidavit, my lord, which was affirmed on 12th November 2025. Page 7 of that supplementary affidavit where my chart is there. Now kindly see, my lord, their chart, Annexure A, page 13. Kindly see the total amount, total awarded amount, 5 crore 40 lakhs 68,436.
5 crore 80 lakhs.
5 crore 40 lakhs. No. 1, 2, 3, 4, 5, 6.
5 crore 40 lakhs.
Yes.
Yes.
Total, your lordship will find 5 crore 40 lakhs 68,436.
Yes.
My lord, that is the amount in my chart also.
Yes.
Then, my lord, they kindly look into my chart. They on 23rd July 2025, they paid 4 crore 86 lakhs, leaving a balance of 54 lakhs.
Yes.
Now, 54 lakhs of principal amount, that is
They are saying
awarded.
it's TDS.
Yes. Question is, my lord, whether they were entitled to deduct TDS if this is the principal amount in any way. Principal awarded amount. They have deducted it on account of TDS, which they are not entitled to as per the decision, because TDS, my lord, on award is not, my lord, there is no provision for deducting TDS on awarded amount. My lord, that is what this honorable court has held. My lord, kindly may I rely on a decision of this honorable court, my lord, reported in, my lord, 2023 SCC Online, Calcutta, 1929 a copy দিয়ে other side কে একটা copy দাও। First paragraph. The question which falls for adjudication in the present case is whether the award debtor, being the Union of India represented by the Chief Engineer, Metro Railway, can deduct 10% of the amount awarded to the award holder and pay the balance amount to the award holder. Then may I kindly come to the next page, paragraph 4. The grievance of the award holder is that instead of rupees 3.88 crores, which was recorded in the order dated 4th May 2023, the award holder received an amount of only rupees 3.5 crores. The difference of the above rupees 38 lakhs was a result of the award debtor deducting TDS on the said amount. This was the express stand taken on behalf of the award debtor. Then, my lord, kindly omit paragraph 5, kindly come to paragraph 6. Therefore, the issue is whether the award debtor, Metro Railway, could have deducted 10% from the award amount of rupees such and such as TDS and paid the balance amount of rupees 3.50 crores. Now, my lord, kindly come to paragraph 8. Relies on a Supreme Court judgment. Kindly turn the page to cut short the matter. Second line, the ratio of the decision is that the amount payable by the appellant employer who terminated the contract to the respondent was no longer to be viewed as salary but as judgment debt, and that the appellant hence could not deduct tax at source before making payment of the decretal amount to the respondent. Then the dictum of All India Reporter was reiterated by a division bench. Kindly, my lord, in a 1984 SCC, kindly come to paragraph 10. The decisions following All India Reporter hold that the decretal amount is a judgment debt and must be paid in its entirety to the decree holder. No amount can be deducted as tax at source from the decretal sum, and that the judgment debtor is not entitled to pay only the balance amount of the decree holder to the decree holder. This is the position in law. The action of the award debtor Metro Railway in deducting 10% from the awarded amount of rupees such and such as TDS and paying the balance amount of rupees 3.50 crore to the petitioner award holder is hence contrary to the settled position of law. Then, my lord, 12. EC number such and such is accordingly disposed of by directing the award debtor to pay this.
Well, if I, my lord,
And my lord, to my knowledge, my lord, this has not been upset.
Well, if I explain this judgment, well, this judgment, my lord, comes out in respect of a salary of a person who's
No, sir, it's not only about the salary.
Yes.
Even if
Yes.
you look at the TDS, sir.
My lord, yes, my lord.
Sir,
but-
please, it is regarding the TDS also. It's
Hello.
regarding income tax as well as TDS or any statutory tax which has to be deducted. It says, it is very clear, even in para 11, the action of the award debtor Metro Railway in deducting 10% from the awarded amount so-and-so, paying so-and-so, is hence contrary to the settled position of law. What more clarity do you want?
My lord, only, my lord, I want to rely upon, my lord, section 194I of the Income Tax Act, my lord. If you lord,
Sir, you can rely on anything.
my lord, there, my lord, says that I am entitled to, my lord, take deduction of TDS in respect to when the rent is payable to the.
Sir, we are not talking about rent. We are talking about an awarded amount.
Well, ultimately, rent culminating the award. my
You
lord.
please overcome this judgment. Then we can look at other provisions of law also.
Well, in this judgment, my lord, as I have understood, subject to your lordship correction, my lord, this is, if your lordship takes, my lord, at page, my lord, prior to paragraph 9, my lord. If your
Sir, you
lordship-
just read paragraph 11,
My lord.
the first line.
I've read, my lord.
Yes.
Award holder, the award debtor Metro Railway in deducting 10% from the awarded amount to such and such and paying the balance amount of such and such to the petitioner is hence contrary to the settled position of law.
Just stop there, sir. Just stop there and think about what it is saying.
My lord, this, my lord, subject to your lord's comment, this is, my lord, this has been held by the honorable court, my lord, relying on the judgment of that, my lord, that All India Reporter matter, my lord. There, my lord, that the subject matter of that issue was regarding, my lord, salary.
Agreed, sir. That principle has been applicable in this matter also now.
But this is only in respect of salary, my lord. That I want to emphasize your lord, my lord. Here, my lord, the metro rail deducted the TDS. My lord,
I can't argue with clear propositions of law, na, sir. Very difficult to argue with you regarding clear proposition of law. They have relied on a judgment where the salary has been deducted.
My lord.
The same analogy has been put here also in this award where the TDS has been deducted. What more clarity do you want? I don't understand that. It is either Mr. Bhattacharya you want to understand or you don't want to
My
understand.
lord, I understand, my lord. I understand. Your lordship confined to the paragraph 11, saying that TDS is not deductible.
Correct.
My lord, in that event, my lord, if that is so, my lord, then paragraph 12, my lord, liberty should be given to us, my lord, so that we can take back the money and pay to them, my lord. Paragraph 12, my lord, it has been categorically stated that you take back the money and make all arrangement for taking back the money and pay to the, because money has to be paid because we have paid it. Had it been the case that we have not returned the money, we have paid in other words, my lord. That liberty should be given to us so that my lord take back the money and pay it, my lord.
Whatever liberty you want.
And only, my lord, interest part should not be there, my lord. My lord, that money has been paid. They are asking for interest on interest, my lord.
Well, it kindly consider paragraph 9. This liberty was granted also. That you take back from the department the TDS amount.
Yes.
They will take it back. Let them pay the money, my lord.
Whatever they have to, they will do it.
It's from one pocket to the other, but let them do that.
Is there any contrary law you want to show? Then I can.
Only, my lord, provision of income tax act says, my lord.
Income tax act is not applicable here. Anything else you want to show? You tell me.
The other decision we have searched it out, my lord. There is no such decision on this aspect, my lord. Whether
all right.
But in all respect, I am saying, my lord, Supreme Court also held that you to take steps, proper procedure to get back the money from the income tax department and pay it to the award holder.
Take down. The awarded amount is 5 crore 73 lakhs 12,244, right?
The amount is 5 crore 40 lakh, my lord.
All right.
68,436. The parties are ad item on that. That will appear from their chart at page 13. That will appear from.
Execution application has been filed in respect of the arbitral award dated 24th January 2024. Full stop. The awarded full stop. A typographical error in the said award was subsequently corrected on 28th March 20. Oh, sorry. A typographical error in the said award was subsequently corrected on 28th March 2024. Full stop. The execution application was thereafter filed on 29th August 2024. Full stop. The awarded amount is rupees 5 crores 40 lakhs 68,436. The department paid a sum of rupees 4 lakhs 86,000
4 crore 86.
4 crore 86 lakhs 61,592. The balance principal amount, according to the petitioner, the balance principal amount stood payable at rupees 54 lakhs 6,844. He further states that the interest on the principal amount at the rate of 12% per annum from 28th March 2024 to 23rd July 2025 has accrued to 85 lakh 67,995. The department thereafter made a further payment of 77 lakhs 11,195 on 7th November 2025. interest on the principal amount calculated at 12% per annum for the period 24th July 2025 to 7th November 2025 has further accrued to rupees 1,88,425. Learned Senior Counsel, Mr. Mitro, for the petitioner submits that the total end amount payable to the petitioner as on 7th November 2025 is 64,52,069. Full stop. Learned Counsel for the respondent has filed an supplementary affidavit stating that the respondent has already made a payment of 4,86,61,592, which is not under dispute between the parties. He further states that the respondent had deducted an amount of 10% as TDS, amounting to rupees 5,40,68,436. 5,40,68,436, and that the petitioner has been wrongly claiming the had deducted 10% TDS of rupees 54,06,844. Full stop. Not 5 crores 40 lakhs. 54,06,844 as 10% TDS. It is stated by the learned counsel for the respondent that the said 10% TDS amount has been deducted on the principal awarded amount, and the same has been deposited with the statutory authority. Full stop. Learned counsel for the petitioner states that the deduction of the 10% was legally not tenable in view of the judgment relied upon by the petitioner in 2023 SEC Online Calcutta 1929. Full stop. Learned counsel for the petitioner states that the court had categorically held that the deduction of 10% TDS is contrary to the settled position of law in terms of All India Reporter versus Ramchandra D. Datar AR, All India Ramchandra D. Datar AIR 1961 SC 943. Full stop. The same principle has been applied to the judgment relied upon by the petitioner. Full stop. In view of the settled position of law, this court EC so-and-so is accordingly disposed of by directing the award debtor to make the balance payment of rupees. How much is the balance payment, Mr.
My lord, that would appear from its my lord 64,52,069. Page 7.
That would be slightly
My lord, minus 1,88,425. That is on, my lord, they are asking for interest on the 54 lakhs TDS.
all right. So I'll calculate that amount.
My lord. Well, according to me, my lord, the only TDS amount which has been deducted from the interest and also the principal
TDS
amount, that amount has
and
to be refunded to
interest on the amount 54 lakhs from my lord the date of the 2 months after the award.
Yes.
The award.
I have to do this calculation. Heard?
I was checking the accounts, my lord. It's
Either you
appears
give
to
me a
be-
calculation sheet because
I shall do that.
Mr. Mitra, the problem is that if you actually look at it, they have made the payment. Rightly, wrongly, what they have done is they have made the payment. They have deducted the 10%, which they should not have. So obviously you are entitled to
Here, I
that.
shall give a chart, my lord. Tomorrow,
Give me a
54 lakhs interest at the rate of 12% on 54 lakhs from my lord 2 months after the award, as the award provides, till my lord that date.
Till that date.
My lord, I am denying this allegation, my lord. It is award does not, my lord, provide such payment can be made. That is, my lord, I will explain then award, my lord. According to me, my lord, only TDS which has been deducted by the government. My lord.
Your affidavit is here. I am deciding on the basis
Yes,
of your
yes,
affidavit,
my lord,
sir.
my lord, my lord.
All right. Your affidavit has taken care of everything.
My lord.
Heard? Reserved. You please give me
I
that.
shall hand it over to your lordship.
Because I can't do it in the.
No,
it's difficult.
Not for me, my lord, at least. Possible for me.
But a copy should be given to me so that I
Yes,
can also go through it, my lord.
What copies?
The calculation which my Mr. Mitra will give to you, lordship, my lord.
Calculation is to assist the court.
Yes, that is the.
All right. It is not to be disputed. I
No,
will
I
only,
am not.
that's
No, I am
only,
not.
that's only an assistance to the court.
My lord, my lord.
All right. You can also give your calculation.
My lord, I will give calculation. My lord. I will,
You give your calculation, let him give his
my
calculation.
lord, my lord, my lord.
All right. Tomorrow you give me the calculation. Heard CAV.
Awarded date থেকে 7th
You have nothing to do. You enjoy.
My lord, may I beseech your lordship only one my lord, mercy to your lords, my lord. My lord, the remarks which have been made in the earlier order may be expunged, my lord.
I have expunged to most.
No, my lord, some remarks are still there in the order.
Only few are there. At least that much you deserve.
Kindly, my lord, kindly expunge that, my lord.
That much you deserve.
I beseech your lordship, my lord, kindly
So,
expunge.
Bhattacharya, that much to should let that much be there.
এই সপ্তাহে পড়তে ইন্টারেস্ট হলো না এই অবধি 7-11
Without your saying, I have expunged most of it.
11 তবে হিসেবটা মিলবে না ভুল হিসেব
Yes,
Yes, sir, my lord.
I am obliged. Just give your calculations.
কালকে সকালে
That's your job.
first thing I'll ensure matter
Yes, please.
it would be given to your lordship's
Yes,
office
please. Thank you.
cost titleটা লিখে
Next.
My lord, this is my section 9 application, my lord. My lord, there is already a subsisting order of injunction that has been passed in.
The matter is appearing wrongly in the list, my lord.
Yes, my lord.
It's
My lord, if my lord kindly takes up my lord's last order of 11th November,
Yes.
the interim order was extended for a period of 6 weeks, which is expiring somewhere in 23rd December. And the matter was supposed to be listed after 4 weeks. 4 weeks has not expired. My lord, settlement talks are still going on. If my lord will kindly.
My lord, another thing, my lord, settlement is going on, my lord. My lord, it will take some time, my lord. Kindly keep this matter after vacation, my lord.
After vacation?
My lord, the interim
do it
order is
before.
expiring on 23rd December. If
Do it
my lord
before
is
the vacation.
pleased to keep it on the month list of
So
January.
settlement is still going on, my lord.
Then the interim order will expire. Then I have to extend the interim order.
Your lordship can extend the interim order for 2 weeks, my lord.
So interim order is expiring on 23rd of December according to him.
23rd, yes, my lord.
So either you come back before that.
Great.
Come back before that. Come on the 19th then. Or 18th. 18th of December.
Great.
Learned counsel for the parties state that they are exploring the possibilities of an amicable settlement. Both the councils pray for a short adjournment. Let this matter be listed on the 18th of December.
Beautiful, my lord.
I am for the petition.
Lordship, I am appearing for the respondent in this matter.
Yes.
Lordship, on the occasion, there was a direction for filing opposition by us.
Yes.
Lordship, that has not been filed. I will pray for an extension, though they have filed a section 11, which is pending before the Honorable Court. Lordship, we are not on the way of appointment of an arbitrator. So the
When did you file your section 11?
Well,
Section 11, when did you file?
section 11 the same time the same day we came with the section 9 and section 11 application.
Lordship, for the last 2 occasions, they have been taking adjournment in the section 11, and so the arbitrator could not be appointed.
Why are you taking adjournment? Let the arbitrator be appointed.
Yeah.
We'll send this section 9 also there.
Yes.
Very let these two applications be hard together. No problem.
Sorry?
Let those two applications be hard together. About let the section 11
Section 11, first you have to get the arbitrator appointed. Then only I can refer this before the arbitrator. Why you are taking time there?
Today also it is listed, Lordship.
Don't take time. Get the arbitrator appointed so that you can finish.
Let the affidavit be exchanged by the meantime. my lord.
Last time also you sought time.
No, Lordship, last time the direction was given for affidavit. Lordship,
All right. Learned counsel for the respondent, Shraisi Das, seeks and is granted further time of 2 weeks.
Lordship.
2 weeks to file her affidavit in opposition. List after 3 weeks. Shall we keep it on the 18th?
Lordship.
By the time you'll get the arbitrator appointed?
Lordship.
18th.
Lord, in this matter, Lord, your Lordship, the property was sold, Lord, and your Lordship had directed, Lord, we had to hand over the title deeds to the learned receiver, Lord, and a further remuneration of 15,000 is to be paid. Lord, that, Lord, is slightly delayed, Lord. The dealing officer, Lord, is unwell. Lord, kindly, Lord, keep it after 10 days, Lord. We'll comply with the direction with regard to, Lord, the payment of the remuneration, Lord.
You are the receiver?
No.
I have got the award data. My property was being sold.
Yes.
Pursuant to the order of 25th July 2018.
So,
So I have no difficulty. Property has been sold. They have got the money. Now the order of 2018 records that this property, which
Conveyance has also been executed.
Conveyance has also been done. So this property which is being sold, that will be utilized for paying off their dues. Now they have got the money. Now the dues have been satisfied.
No, dues have not been satisfied. No.
Order of 12th October 2023 by which my bank accounts were injected. I am only saying that kindly allow my banks to be operated.
No, my claim is much more.
Since 2023, it is been injuncted. Now, one of the property has been sold, substantial money received. At that point of time, when the injunction was granted, if your Lordship kindly sees this order, at that point of time, the property was not sold.
Which order?
Your Lordship will see this order of dates I have handed over.
Lord, my claim is more than 4.5 crores. The property is sold for 1.5 crores. So, Lord,
But the execution has been only for, not for, they are adding interest. But this injunction was granted when the property was not sold. Now they have got the money. Now I should be allowed to operate my business. What is the point of holding my account for no purpose? You are getting the money. I should also be allowed to do business.
He is not getting the entire money.
I'm not able to understand.
don't know
Lord,
what is the
Lord,
adjustment
according to my land firm, Lord, we shall file a supplementary affidavit, Lord, to disclose my claim under the award and the amount I have received.
Submission, your Lordship will kindly have a look at this order of 25th July. It says it will be adjusted to the pro tanto satisfaction.
Pro tanto satisfaction, not full and final settlement.
What exact views we are not aware. But my bank.
So we shall file an affidavit, not disclosing the affidavit. Yes.
Inoperative from 2023. Lordship, kindly allow me to operate my bank account.
Lordship keeps it after a fortnight. We shall file a supplementary affidavit, Lord, and also disclose the amount.
I'm not a fly-by-night operator. I'm not running away. I'm doing my business in Calcutta. They are selling my property. Let them sell. They have got the money. Property has been executed. I kindly allow me to operate my bank accounts only to do business. If I am not allowed to do business, this will not serve their purpose in any manner whatsoever in getting the money executed.
Who is the receiver?
My Lord, Mr. Mukul Mukherjee, my Lord, an advocate, my Lord, Bar Association Rule number 14. He's not here today, my Lord, but we'll forward him the title deeds, my Lord, and also his remuneration.
My humble submission is that my account remaining unoperational is not benefiting my learned friend in any manner whatsoever.
How is that, Mr. Sinha, helping you, his account?
Yes.
My Lord, he's the judgment data, my Lord. He's, my Lord,
I know.
either, my Lord, he pays our dues. My Lord, he, my Lord, cannot operate his, my Lord, he cannot, my Lord.
What is the
Lord, about 3 crores is outstanding.
No,
So that's what.
in the account?
My Lord.
How much is the money lying in there?
Lord, that exact details, my Lord, we do not have, my Lord. He can indicate, my Lord, what is the exact amount.
More than 40 to 50,000. And it is a current account that money comes in. That I am not able to operate the same at all. I am not doing.
So he's probably operating other accounts, my Lord, not using that. So he's probably operating other account, not.
If this is the business account,
Yes.
then what is the difficulty? Let him operate.
And property.
Lord, he'll take away, my Lord, whatever is there.
3,000.
Lord, we do not know.
No,
Lord.
it's
We really
not
do
that.
not know, Lord, what is the amount
The
due.
due is 3 crores or not. We also don't.
Lord, I'm saying, Lord, this order is there for last, Lord, 2 years. Lord, kindly keep it after a fortnight, Lord. We shall file an affidavit.
I'll keep it after fortnight. It's
Yes.
not that it's your matter of right that you can see.
Yes.
Matter of right, but kindly see the
Let that be
execution
attached.
petition. It is the
That's
claim.
okay.
Is not
This is only part payment which has been received. The entire awarded amount is much more than what they have
No,
been.
no, no. Kindly see the execution petition. What is their claim? It is not 3 crores. Kindly see the tabular statement. It is not with me right now, but kindly see the tabular statement. What is their claim?
Let them file it.
It is not 3 crore. What is submitted?
No, that's in 2018, my Lord. Interest, my Lord, for 8 years, my Lord.
Sir,
Yes.
at the time when he has filed it, this 2018. The
But should
interest
be-
doesn't stop. 42
doesn't
lakhs
stop.
becomes 24 crores.
But this property execution was being kept on hold from 2018. The order was
Alright.
passed in 2018.
That's all right. You don't have any right
Oh,
to get
they
your
have got my property. They are selling it away. This property was given as a settlement
payment,
process. For
make the entire awarded amount payment with the up-to-date interest. Everything will be opened.
Yes, Lord.
Tomorrow
Everything
I'll
will.
open the bank account.
This property was.
Tomorrow I will open the bank account.
And I don't know
Otherwise,
what is the due. What are the dues?
My Lord, in our GM, my Lord, we
who
have
knows
disclosed
better
4
than
lakhs.
you? You don't have the award.
No, Lordship. The awarded amount is much lesser than the property which
What
has
is
been
the
sold.
interest on the awarded
My Lord,
amount?
the last, my
You
Lord,
can
the,
calculate. You can't calculate that.
Lordship,
Don't make
the-
those kind of submissions here in the court. that you don't know what is the awarded amount? You
Awarded
don't
amount
know?
is much lesser than what the price. they
Whatever it
received.
is, do you know the awarded amount?
Less
You
than a
know the
crore.
interest?
Less than a crore.
You know the interest on it?
Your Lordship, interest is
So calculate the
9% per annum.
interest. Yes, calculate the interest.
Right? So that is lesser than the amount which they have received now.
They are saying it's much more.
That is what the
File your
submission is.
affidavit stating that the execution petition has been satisfied, the awarded amount has been paid.
Your Lordship has seen the
File your
2018
reply.
order.
File your reply.
I will file my reply.
What reply?
File my
I'll
reply
file,
to the
I'll file a
Put the
supplement.
calculation before you make all these statements. Tell me the awarded amount.
Your Lordship, they have to give the
Tell me
calculation.
wait a minute. Tell me the awarded amount.
And awarded amount is not right now with me. The
What is
execution-
there with you? Tell me what is there with you? You are making all these statements. What is there with you? Do you have the file?
No, I don't have. Because it has not been served.
You make statements like this without even coming with the file.
Your Lordship, the
Is this the way you address the court? What is your name?
Your
Is this the way you address the court?
Lordship, the fact.
Don't speak if you don't have the file. Please don't speak. And maintain the dignity of the court. You seem to be a senior person. You're coming to the court without the file and making all kinds of statements. Is this the manner you address the court? How can you even speak without the file? You're not a junior. I've seen you in the court.
Yes, Your Lordship.
This is how you treat the court.
No, Your Lordship, I apologize for that, Your Lordship.
That you'll come and make any kind of statements. And on the top of your voice.
Your Lordship,
Even your file.
I tender my apology, Your Lordship, for that. If I have offended the court, I tender my apology.
Sir, please have some respect.
No, I really do tender my unconditional apology, Your Lordship, for
So unfair.
offending the court.
For
I'm
somebody
very
like
sorry.
you,
I'm very sorry, Your Lordship, for offending the court. I should not.
I can understand this coming from some lawyer who doesn't have that many years. Somebody like you making these kind of statements without a file. Overconfidence is not good. Please. You all are at that age where we look up to you for so many things. You're one of those members of the bar.
No, I tender my apology, Your Lordship, for I should not have offended. Kindly accept my apology, Your Lordship.
Not from you.
Kindly accept my apology, Your Lordship. I'm very sorry.
Don't do that. Yes, Mr. Sinha, tell me.
Yes, Your Lordship, not keeps it after a fortnight, but I'll file a supplementary affidavit to disclose what exactly is the amount but after giving credit. And by that time, we would have also complied with the direction with regard to payment of receiver's remuneration.
Mr. Sinha, the extension is granted. 2 weeks time to make the remaining payment of the receiver. Let the same be done. Let this matter be listed after 3 weeks.
Yes, I also was praying for since the property has also been already been sold. I was also praying for leave to forward the original title deeds to the receiver so that he can hand it over to the purchaser. Not because sale has been
Original
confirmed.
should have been with the receiver.
Yes, not he is now requested for it. We'll forward it to him.
The receiver will
Yes,
do it.
yes, we'll give it to. It was mortgaged to us, so it was with us. We'll forward it to the receiver so that he can forward it to
Receiver,
the.
he'll do the needful.
We'll
He
do it.
has been appointed for this very purpose.
Yes. So I'll forward it to the receiver.
List after 3 weeks.
Should I again tender my apology?
Not from you, not from. You know, if it was somebody else, I wouldn't have said anything.
No, very
But
sorry.
not from lawyers like you, shouldn't do this.
Sorry for offending the court. Very sorry.
What will the juniors learn from you? You are at that level now.
Very sorry, Your Lordship.
Very soon you'll be designated and all. You know, if this is the conduct, what will happen?
Extremely sorry for offending. I should not have. Grateful, Your Lordship, for the.
Okay. On the list. Okay. Item 4 से ये ना 4 पे प्रीमियम एग्रो ये तो ये कॉल हो गया ना ये तो 4 to 6 तो हो चुका है अगर पर no. Yes, item 4, monthly list. Yes.
Lordship, in this matter, I appear on behalf of the respondents. Lordship, this matter, I'll just briefly apprise your Lordship on this. Lordship, there was an order of. Lordship, kindly comes to page number 21, Lordship. Lordship, page 21, Your Lordship. This is the Section 9 application that was filed back in the year 2015, Your Lordship. Lordship, post that. Lordship, if Your Lordship kindly comes.
Is it settled?
Lordship, the account is not settled, Your Lordship. Our money is involved here. Lordship, we have invested in accordance with the compliance of the order of this court.
Order records that the claim had been settled between the
Lordship,
parties.
we had to put in some documents, Your Lordship, with relating to. Lordship, I'll apprise the court. Your Lordship will understand this. Lordship, kindly comes to page number 112, Your Lordship.
Yes.
Lordship, this order was passed in this matter. Lordship, the relevant paragraph is at running page 4 of that order, Your Lordship, page 115. Lordship, the court is of the view that the sale is not in accordance with law and the award has not yet been served upon the petitioner. So we were directed to pay 5 lakh rupees. We had done that. Lordship, this was a conditional order, which is there in the next page, Your Lordship, page 116. Lordship, in the event the award is not challenged within a period of limitation, Lordship, as prescribed in the statute, the respondent shall be entitled to apply for release of the security deposit. Lordship, since then, there has been no challenge, Your Lordship. Our prayer is very limited, Your Lordship. We have made communication to that effect to the department for releasing the money, which is at the subsequent page, Your Lordship, in page number 117. We have made communication, and a communication was also received from the registrar, which is at page number 118. They state that our vakalatnama is not there, so that's the only reason we cannot retain the money. We cannot claim the money back. Lordship, we just need a direction for just getting the payment back, Your Lordship. Our money is involved over here. No challenge has been put in effect, Your Lordship. And post that, just we need a 5 lakh rupees that has been invested along with the interest, Your Lordship. That's the only reason we are asking.
And what is the petition filed?
Lordship, the petition was a Section 9 application wherein
That's it.
there's a pre-award section and the matter has already been disposed of.
So you furnish your vakalatnama, you'll get the money back.
Lordship, furnishing the vakalatnama, post that, Your Lordship, they need an order, as because we have filed this application here, Your Lordship. Post that we cannot do that.
So you had never filed the vakalatnama?
Lordship, we had filed the vakalatnama back then, Your Lordship, but now in this matter, Your Lordship, as the bare understanding of this, we haven't done this matter back then.
If you had filed the vakalatnama earlier, where's the copy of that? That's what
Lordship, this matter was not assigned to us back then, Your Lordship. Post that, we have been assigned in this matter. We have given our vakalatnama, post that, and there has been a change of advocates, Your Lordship. Now we have to retain that money, Your Lordship. We have to get back that money.
All right,
That has already been invested. Lordship, the DD documents, the DD details have also been there in this application.
Learned counsel for the respondent states that an amount of rupees 5 lakhs was deposited with the registrar original side in terms of the order dated 28th April 2017. As a security deposit, full stop. He further states that since there has been no challenge to the arbitral award within the period of limitation, he seeks the release of the aforesaid security amount in favor of his client. Full stop. He states that he had sent a communication dated 17/6/2025 to the registrar original site for the needful. Full stop. He has drawn the attention of this court to the letter written by the registrar Assistant Registrar, Cash Department, original site, Calcutta High Court, dated 18 June 2025, wherein the respondent has been asked to furnish his Vakaltama in terms of Rule 5 and 6 under Chapter 1 of the original site rules of the High Court of Calcutta. Full stop. It is stated by the learned counsel for the respondent that the client, Cholamandalam Investment and Finance Company Limited, has recently engaged him, and at the time when the order was passed on 28th April 2017, the counsel who was representing the above mentioned client was a different person. Full stop. He seeks and is granted liberty to file his Vakalatnama so that the registrar original side shall do the necessary. With the above direction, you have filed a G also.
Lordship, this is the G that we had filed.
For
And
this purpose only.
For this purpose only, Your Lordship.
And the GA3 is disposed of. This is the GA3.
Lordship, GA3.
This is the direction you are seeking in GA3.
GA3, Your Lordship.
GA3 is disposed of. None
Lordship,
appears for the
Vakalatnama and affidavit of service may be kept on.
All right. And none appears for the petitioner, so dismiss the default. None appears for the petitioner. It seems that the petitioner is not interested in pursuing the present petition.
The matter was earlier dismissed. It's the only GA that's pending. The GA stands disposed of.
GA stands disposed of.
Lordship, the affidavit of service and the Vakalatnama is kept on record.
It is pointed out by the learned counsel for the respondent that the Section 9 application was earlier disposed of. Only the GA3 has been pending. With the above direction, the present GA is disposed of.
Lordship, the Vakalatnama and the affidavit of service.
The Vakalatnama you file in the registry, it's better. Affidavit services taken on record.
Much obliged, Lordship. Lordship, the subsequent matter, which is at number 5, Lordship,
Yes.
the matter has already been.
The matter has settled, my lord.
The car has also been, the name has been changed.
Settlement letter, my lord, and the payment receipt, my lord.
Take down item 5. You are for the petitioner.
Petitioner, my lord.
Learned counsel of the petitioner states that learned counsel of the petitioner as well as the respondent states that the present matter has been amicably settled between the parties. Petitioner does not wish to press the present petition. The same is dismissed as withdrawn.
Much obliged, Your Lordship.
Rest of the matters tomorrow.